Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
For past action. The defendant pleads not guilty to each and every offense embraced in the indictment. Before we begin the trial, I would like to tell you a little bit about what will happen during the course of the proceedings. I want to describe basically how the trial will be conducted and what the attorneys, jurors, and the judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you're to go about reaching your decision, but now I simply want to explain how the trial will proceed. The law applicable to this case is stated in these instructions and those that follow, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charges is referred to as an indictment. An indictment is the formal accusation charging a defendant with a crime, and it is not evidence of anything. The defendant is charged in count 1 with driving on a revoked license. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant was driving a motor vehicle during a time when the defendant's privilege to do so was revoked. The defendant is charged in count 2 with retaliation for past action. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant harmed or threatened to harm the alleged victim, who was a law enforcement officer, in retaliation for anything the law enforcement officer did in an official capacity as a law enforcement officer. The defendant has pled not guilty to the charges. He is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorneys' arguments, and instructions of law, the 12 jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea about what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After that state's opening statement, this says an attorney for the defendant. It's a standard charge, but the defendant himself may make an opening statement if he should so choose. Again, statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. Venue of the offense lies in the county where the offense was commenced or consummated. If you find the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dickson County, Tennessee, then you must return a verdict of not guilty. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After the state's rebuttal, the defense may put on further proof. After you've heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and help you to understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law you are to use in reaching your verdict. After you hear my instructions, I will select and excuse the alternate juror, and the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law and my instructions to the facts, and from that application, you will arrive at a verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt. and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. Thus, the defendant is not required to prove his innocence, to have his attorney make any statements or arguments, or to produce any evidence. Excuse me. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element of proof necessary to constitute the offense. You, as jurors, must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crimes charged in the indictment. You must consider the evidence in each count separately. You must base that decision only on the evidence in the case and my instructions about the law. Witnesses will testify in response to questions from the attorneys. Witnesses are first asked questions by the party who calls the witness to testify, and then the other side is permitted to cross-examine the witnesses. Although evidence is presented by asking questions, the questions themselves are not evidence. An insinuation contained in a question is not evidence. You should consider a question only as it gives meaning to a witness's answer. In addition, members of the jury may ask questions of the witness if desired. The procedure for a juror to ask a question of the witness is that the question must be written down and submitted to me. Do not put your name on the question, as the questions of the jury are required to be anonymous. If a juror has a question that he or she would like to have asked of a witness, that question must be submitted in writing while the witness remains on the witness stand. At the end of the witness's testimony, the jury will be excused, and I will consider the questions of the jury on the record. Then the jury will return to the courtroom. If the question is allowed by the rules of evidence, the question will be asked either by me or by one of the lawyers. You should not place any significance upon the fact that I asked the question of the witness or whether one of the lawyers asked the question. In either event, the question is being asked of the witness solely because it was desired by a juror. The wording of the question may be altered by me, or the question may not be asked at all. If the question is altered by me, you must assume that I had a valid legal reason for altering it, and you should place no significance upon this fact, nor should you draw any inference from it. I may refuse to ask the question at all. In that case, you likewise should place no significance upon this fact, nor should you draw any inference from it. Many times our rules of evidence do not allow certain questions to be asked, even if both sides desire to do so. After the trial, if you wish to know the answer to your question, or the reason that it could not be asked, please ask after court is adjourned, and I will attempt to explain it to you. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness have any motive, bias, or prejudice that would influence the witness's testimony? Did the witness seem to have a memory of the events he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Was the witness distracted in any way? How did the witness look and act while testifying? Was the witness making an honest effort to tell the truth, or did the witness evade questions? Did a witness's testimony differ from the testimony of other witnesses? Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. As the sole judges of the facts, you must determine which of the witness's testimony you accept, what weight you attach to it, and what inferences you will draw from it. The law does not, however, require you to accept all of the evidence. In deciding what evidence you will accept, you must make your own evaluation of the testimony given by each of the witnesses and determine the weight you will give to that testimony. You must decide which witnesses you believe and how important you think their testimony is. You're not required to accept or reject everything a witness says. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules to use in deciding whether you believe a witness. In making up in your mind and reaching a verdict, do not base any decisions on the fact that there were more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you've heard and decide the facts. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness gives. This simply means that the attorney is requesting that I decide on a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from my ruling on that objection. My rulings only relate to the legal questions that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind, and you may not refer to that statement in your later deliberations. In deciding this case, you may not draw any inference from an unanswered question, and you may not consider testimony that you are instructed to disregard. Any arguments about objections or motions are usually required to be made by the attorneys out of the hearing of the jury. Information may be excluded because it is not legally admissible. Excluded information cannot be considered in reaching your decision. A ruling that is made on an objection or motion will be based solely upon the law. You must not infer from a ruling that I hold any opinion, any view or opinion for or against any party in this lawsuit. Some of you have probably heard the term circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw, heard, or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw, heard, or otherwise sensed, they presented direct evidence. Circumstantial evidence is all of the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The court will not provide you with a transcript of the testimony at the end of the trial, therefore you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own use during your deliberations. You're not required to take notes. Independent memory can be as accurate as written notes. You will be provided with a paper and pen if you decide to take notes. There are several rules concerning your conduct during the trial and during recesses that you should keep in mind. First, do not discuss this case among yourselves during the trial until I instruct you on the law and you start deliberating at the end of the case. You must keep an open mind until you have heard all of the evidence, the attorney's closing arguments, and my final instructions concerning the law. Any discussions before the conclusion of the case would be premature and improper. Second, during the course of the trial, you should not talk with any witness, defendant, or attorney involved in this case. Please do not talk with them about any subject whatsoever. You may see them in the hallway or on an elevator or at some other location. If you do, perhaps the best standing rule is not to say anything. Third, do not permit any other person to discuss the case in your presence. If anyone does attempt to do so, report this fact to the court immediately without discussing the incident with any of the other jurors. I do not know if there will be any media reports in the newspaper, on TV, or on the radio about this particular case. If there are, you are not permitted to read, watch, or listen to those reports. You as jurors must base your decision solely on the evidence you hear in the courtroom. You may not communicate with anyone or provide any information, photographs, or video to anyone by any means about the case on your cell phone, through email, Android, iPhone, text messaging, video, FaceTime, Google Duo, Zoom, Facebook, Messenger, Skype, through any blog or website, through any internet chat room, or by way of any other social networking websites, including but not limited to MySpace, Facebook, Instagram, Snapchat, Twitter, LinkedIn, TikTok, Meetup, Pinterest, Reddit, and YouTube, especially including the live stream of this trial. In keeping with the state of Tennessee's open access to the court's public policy, the majority of court proceedings are live streamed via YouTube. You as a juror are not recorded on video or shown on camera. You are not permitted to read, watch, or listen to those YouTube streams during the trial. You as jurors must base your decision solely on the evidence you hear in the courtroom. I will remind you of your duty and responsibilities before all breaks in jury out hearings and trust you will follow my instructions in keeping with the integrity of the case and court proceedings. During the course of the trial, you will receive all of the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. Do not conduct your own private investigation into this case, although you may be tempted to do so. For example, do not visit the scene of an incident, read any textbooks or articles concerning any issue in the case, or consult any other source of information. If you were to do that, you would be getting information that is not evidence. You must decide this case only on the evidence and law presented to you during the trial. Any juror who receives any information about this case other than that presented at trial must notify the court immediately. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing. And in some instances, I may ask you to retire to the jury room while we discuss the matter out of your presence. I'll try to avoid as many of these interruptions as possible. I ask your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. In the long run, they save time for all of us. If anyone needs a break at any time, please do not hesitate to ask. Simply raise your hand. If I do not see you, get the attention of one of your court officers who will advise me that a juror needs a break. Normally, I will try to conclude the testimony of a witness before taking a break. The usual break times are at 10:30 in the morning and 2:30 in the afternoon, with a normal hour between 12 and 1. If you need for lunch, if you need a break at any other time, please ask. A juror who is distracted is not paying full attention to the testimony. Both parties are entitled to your full, undivided attention to the case. If after your deliberations you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. This completes my opening comments to you, and the next phase of the trial is the formal reading to you of the indictments in this case. General Bryson, you may read the indictment.
In the Circuit Court for Dickson County, Tennessee, at Charlotte, November term, Grand Jury 2022. The grand jurors of Dickson County, Tennessee, duly impaneled, sworn upon their oaths, do present that on or about June 18th, 2022, in Dickson County, Tennessee, and prior to the finding of this indictment, Sharik Marquis Vaughn then and there did unlawfully and willfully drive a motor vehicle upon a public highway in Dickson County, Tennessee, at the time when the privilege of the defendant to do so was canceled, suspended, or revoked, in violation of Tennessee Code Annotated 5550-504, all of which is against the peace and dignity of the state of Tennessee. And the grand jurors aforesaid, upon their oaths aforesaid, do further present and say that on or about June 18th, 2022, and prior to the finding of this indictment, in the county and state aforesaid, Sharik Marquis Vaughn then and there did unlawfully and knowingly harm or threaten to harm Officer Lindsay Javins by any unlawful act in retaliation for anything Officer Lindsay Javins did in an official capacity in violation of Tennessee Code Annotated 39-16-510, all of which is against the peace and dignity of the state of Tennessee. Signed by W. Ray Crouch, Jr., District Attorney General.
Mr. Vaughn, as to that indictment and to those two counts, how does you plead?
Your Honor, I would like to change my plea. I would like to plead guilty to count 1 and not guilty to count 2.
All right, ladies and gentlemen, the defendant has pled guilty to count 1, so that count you will not have to consider in your determinations in this matter. He has pled not guilty to count 2, and we will allow that to be entered as a not guilty plea. We are now ready to proceed to the next step, which would be the opening statements, and we're at the noon hour. I would suggest that we begin after lunch with opening statements, and then we move to the testimony. Ladies and gentlemen, I've given you a set of instructions that are how to monitor your progress in this case and how to monitor your behavior. I would just remind you that it's very important that you not discuss this case among yourselves. You're free to go anywhere you want to go for lunch. You're not under any sort of restrictions, but when you come back, you want them down in the jury assembly room. If you'll go back where you went to first thing this morning, they will bring you up through the back elevator and have you in the jury room so that you can kind of keep you isolated from everybody else. So we are now going to stand in recess. We'll give you until, let's try to be back at 1:15, and if at all possible. If it's a little later than that, we won't start without you, but we'll see if we can all be back by 1:15 and get started. We'll stand in recess to 1:15. All right, anything before we bring the jury in?
Judge, I wanted to address one thing briefly before the jury came in. When I read the indictment, I of course read it as would be anticipated for a bifurcated trial. So the defendant is charged with driving on revoked third offense, and I just wanted to be clear for the record that that was what he was pleading to.
It is clear for the record that the defendant is in fact charged with third offense, but because it is a bifurcated trial, I'm sure Mr. Spratt has probably explained that to you, Mr. Vaughn, but a bifurcated trial means under our rules, the jury cannot hear that you have been twice before convicted of driving on a revoked license. They only know that's your charge. So we will have the trial, and because on the third or the second count, but because you have been convicted of a driving on a revoked license, you have pled guilty to that, then it was a third offense. Is there going to be any contest about that being a third offense? Because under the rules, what would happen is that we would have to have a bifurcated section that for the jury to determine whether or not you had 2 prior convictions. What if you don't need it?
I believe the state's got 2 witnesses. I'm not holding them.
Turn your microphone on.
It's on. I'm sorry. I think the state's got 2 witnesses, and I'm not going to hold General Bryson to that, or Mr. Vaughn's not either, but before Corporal Stewart's testimony, we may have a short jury out on an issue with his testimony. But that, I think, should be the only thing that's taken up.
All right. Then you have some issue, there's nothing been filed to my knowledge that would affect that, but we'll take that up whenever it gets to it.
And, well, I can address the reason it hasn't been filed to now or wait.
Do what?
The reason that it hasn't been filed,
Go ahead.
because I think it just probably came to light at the motion hearing. Necessariness for it. Necessary, as to the necessity of it. I'm sorry.
All right, well, the jury's been sworn, we're proceeding with the trial. He's pled guilty to count 1. We will move to count 2, which is count 2, because we've obliterated the original count 2, and now count 3 is count 2. So let's go ahead and put on our proof regarding that, and when you get to a witness that you need a jury out hearing, you will need to allow me to let me know, and then Mr. Vaughn can argue as whatever it is he wants to argue. All right, bring out the jury, please. All right, thank you, ladies and gentlemen. We are now ready to proceed with the opening statements of the parties if they choose to make one.
You are going to get a snapshot of the incidents that happened on June the 22nd of 2022. The defendant having already pled to driving on revoked, the state will be presenting proof, in our case in chief, only on the charge of retaliation for past action. Now, what you will hear in the proof is that on that night, Officer Javins had a reason to stop and talk to Mr. Vaughn, and that Mr. Vaughn, the defendant, was arrested. You will be able to see the video of when he arrives at the jail and begins to make comments to Officer Javins. Okay. You will be able to hear his exact words. It will be up to you to decide exactly what those words are. Some of the ones that will be fairly clear will be, I am a threat for a reason. Okay. When Officer Javins finishes up her paperwork, she needs to retrieve her handcuffs. When an officer arrests a person, those are that officer's handcuffs. And when that person is in the custody of the jail, it's normal that they switch out the handcuffs and put jail cuffs on, and the officer takes their cuffs with them should they need to make any other arrest. It is at that point that Mr. Vaughn is going to begin to become agitated, to become upset. He will state that he does not want this officer, a female, touching him. He will say that if they take the cuffs off, he's going to break her jaw. He will make several comments that you will get to hear while Officer Javins is there. And then later on, you will hear from another officer that will talk about comments later on. And all of those comments taken together will be the state's proof for retaliation for past action, which is the making of a threat against an officer for actions taken in the course of that officer's duty.
Mr. Vaughn, you may address the jury if you choose, or you may waive your argument. Mr. Vaughn, do you wish to address the jury?
1 second, Your Honor.
If Mr. Vaughn is going to address the jury, he must do so now.
Your Honor, I wish to waive open statement and reserve for defendant's case in chief.
All right, defendant has waived his right to make an opening statement, so General, you may start your proof.
State calls Corporal Lindsay Javins.
Affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth.
Are you Corporal Lindsay Javins?
Yes, ma'am.
Now, some people say Javins instead of Javins, is that right?
Yes, ma'am.
We are ringing a little bit.
Yeah, I think it's me.
Would you spell your first and your last name for our court reporter?
Lindsey. My last name is Javins.
And how are you employed?
Oh, the City of Dixon Police Department.
And were you working for the city in June of 2022?
Yes, ma'am.
How long have you been in law enforcement?
Since 2017.
And is Dixon Police Department the only law enforcement agency that you've worked for?
No, ma'am. I previously worked for Fairview Police Department.
And on June the 18th of 2022, did you come into contact with the defendant?
Yes, ma'am.
And as part of that conduct, did you end up placing him under arrest?
Yes, ma'am.
We are going to focus on the events once he is taken to jail. So are you and he the only ones in your patrol car?
Yes, ma'am.
Were there other officers on scene earlier?
Yes, ma'am.
So once you arrive at the jail, explain to the jury sort of the sally port and how it goes to take someone into the jail.
Yes, ma'am. So whenever you pull into the jail, you drive around the side. There's a front gate. You press a button, tell them what you're there for. They let you in the front gate. And then you go to another gate, and that gate opens. And then you go into a sally port, which is essentially like a kind of like a pull-through garage. And it's a secure area to bring whoever into the jail. So we were in that sally port area. That's essentially like a garage. There's a door right beside where you would park your car to enter into the jail booking area.
On the ride to the jail, was the defendant, describe his demeanor.
On the way to the jail, like when we first started driving to the jail, we had been joking around and talking. We had just had a pretty reasonable conversation at the police department. We were on good terms at that point in time.
Is that unusual when you're transporting someone?
Not usually. I mean, after a point in time, sometimes people will, start having conversation with you. Sometimes people are mad the whole time. It fluctuates.
And did he remain calm or did he become agitated at some point?
He remained calm until we got to the sally port.
What is the first thing that you would pinpoint as him getting agitated?
Whenever he said that my name's not Lindsay, when he was getting out of the car, and then he said that I lied to him like all women do.
And how did it go from there?
So he is stepping out of the car. As he's getting out of the car, he said, "Your name's not Lindsay." And I said, "Yeah, it is Lindsay. My last name is Javins," because our name is on our uniform, and he saw the Javins. I said, "I just typically do first name basis with people because it's easier to remember than Javins. Javins is kind of hard to remember." So he started getting upset about that. And he was like, he said that we had made peace, and then I had lied to him, something to that effect of that I lied to him about my name and that we weren't cool anymore, basically. And then as we start to enter into the jail, that is whenever he said, I'm a threat for a reason. I misheard him. So I said, what? You're a what for a reason? Or you know what for a reason? And he said, I'm a threat for a reason.
Is that the only thing he said that gave you concern?
No, ma'am.
Now, I'm going to pass up in just a minute a disc and ask you if you recognize it, and give the jury an opportunity to view the video. But could you hit some of the high points of why the statements he made that were concerning to you?
So the first one that was bad was whenever the jail staff was trying to take the cuffs off of him. He was upset because I was assisting the jail staff. There was one person on his left arm and there was nobody on his right arm. And there was who I don't even know the jailer's name. I presume him to be newer, kind of inexperienced, and he was standing just directly beside us. He wasn't doing much other than he was about to unlock the cuffs. So whenever Mr. Vaughn started pulling around, I went and grabbed his right arm, so just one officer wasn't assisting. At that point in time, he's upset because I'm touching him, and more deputies come. And whenever other people get there, I step back, thinking that if I'm no longer touching him, it's going to de-escalate the situation. And at that time, he said, when her jaw gets broke, it's your fault. And then he continued, fighting with them. And then a female jailer said, will you stop tensing up? We're trying to take these handcuffs off. And he said, excuse my language, fuck no. I'm going to beat that bitch up. Something of that effect. Then, probably one of the things that made me feel uneasy the most is after they got the cuffs off, they walked him to the jail doors for the holding area where they were putting him in. And he said, he looked at me and he said, laugh if you want to. You live in Dixon, Fairview, you talk too much. Implying that I had told him too much information about myself, because I had told him that I'd previously worked for Fairview Police Department. So he was saying to me that I live in Dixon or Fairview, that I talk too much. So I told him too much information about myself.
Did he make any, did he call you by name during any of these threats?
During the actual threats, no. At one point, he did call me by name, during the incident inside the jail, yes.
Was anything in his body language suggestive of who he was talking to?
Absolutely. There in several times he was speaking.
Objection, Your Honor. Speculation.
All right, restate your question.
I asked if there was anything in his body language that indicated to whom he was addressing with his threats.
Overrule the objection. She can testify about what she observed and what, that led her to believe, but that goes to the jury to determine whether or not that's reasonable interpretation for what she saw.
Officer, was there anything in his body language that indicated to who he was speaking about?
Yes, ma'am. So whenever he was speaking and he would say her, he was leaning towards my direction. One time he even looked at me. And there's another time that he's walking towards my direction and staring me down right before another officer grabbed him.
I am going to pass up a disc. We will refer to this as Exhibit 1. Do you recognize what I've just handed you?
Yes, ma'am.
What is it?
It is the disc that contains my body camera footage from that night.
And have you had an opportunity to review it?
Yes, ma'am.
Is it a true and accurate reflection of the events as they happened that night?
Yes, ma'am.
Judge, I would move this in as Exhibit 1,
We'll mark it as Exhibit 1.
and then after the clerk has marked it, I would like to retrieve it. Corporal Javens, did you, and you said that you reviewed it, you actually listened through this a couple of times, is that correct?
Yes, ma'am.
And did you take the time to prepare a transcript of what you heard on that recording?
Yes, ma'am.
Judge, at this point, when I play the body cam, actually, I'll pass up to Corporal, is this the transcript that you prepared?
Yes, ma'am, it is.
And to the best of your knowledge, is it a true and accurate reflection of what is on this recording?
Yes, ma'am. There are pieces that I think that is documented on there that it may say like we couldn't understand what he was saying. There's some things that, especially at the end, that you couldn't hear exactly what he was saying whenever he was in the holding cell. There were only a couple comments that you could actually make out. So it doesn't have every single line, but it is pretty accurate to what's on here is what I heard on the video.
Judge, I have previously provided a copy of this to the defense. I would like to move it in as Exhibit 2 and allow the jurors to have a copy as they listen to the recording.
All right. Ladies and gentlemen, this is a transcript this witness has prepared based on her interpretation of what you're hearing, about to see and hear on this recording. It is up to you to compare that to what you hear on that to determine whether or not that is an accurate transcription.
Sorry, Judge, the state of Tennessee's firewall was not playing nice with the video. All right.
Reboot what? What are we rebooting? Go ahead. Ladies and gentlemen, since it looks like we're in a stalled here for a moment, why don't you step across, leave those copies of the transcript in the courtroom and go ahead and step over to the jury room, and we'll call you when we have everything ready. General Bryson, I'm going to step off. As soon as you can get that in working order, let me know.
Do that period of life. Now, if you remember last time, it did work at the
Been there.
Now I know which one to turn off.
How long?
I'm glad you said that, because I had it down before, and then the other day, set something on.
Nixon Chantry on the 31st. 1, 2, 3. I just thought it was only supposed to be 3. October 28th.
I have it.
Okay. So what are you asking? You said
That's
there,
what I wanted to make sure you have, because
you can put it down, say 4 days. I'd actually given that day out to some Chantry cases in anticipation that maybe it wouldn't take the full 4 days. Sounds like that's not gonna work.
And, Attorney Davis, that was a plea at 8:30. Yeah. I didn't have my calendar when I.
November the 7th. What is the charge on that one? All right, are we ready for the jury? Let's bring the jury in.
Judge, I'll go ahead and say for the appellate record, there are 2 files on this. Yep. For the appellate record, there are 2 files on this, and I will be playing from the second file. And then I'll put my times on when the jury comes in here. All right, Judge, are you ready for me to begin playing?
We are ready.
Judge, for the record, I am beginning to play on the video screen time, so that would be the real date and time, at 22 hours, 27 minutes, and 8 seconds. And I may pause at points. I'll note that for the record.
You want to get out this way or on that end? Whichever one's easiest for you.
Your name ain't Lindsay.
That's my first name. My last name's Javins. Javins.
So you just lying to me like all women.
My name is Lindsay.
I just gave you respect. I'm taking
Lindsay Javins. Look, I try to be like first name basis with people. Lindsay's way easier to remember than
What you're
Javins.
supposed to do.
Yeah, like Lindsay's.
And when y'all got me last time on a lawsuit, you're straight.
What do you mean?
I'm gonna meet you in person. I'm gonna let you know.
Where's your
Don't play
reason
with
for
nobody
that?
that's peaceful. You better get you.
I'm not blaming nobody that's peaceful. I was being peaceful until you wouldn't get out of the car.
Disrespectful as I was.
Come on, man.
I'm a threat, though.
Come on,
I am
man.
a threat for a reason.
What?
I'm a threat for a reason.
You know what for a reason?
I am a threat.
Oh, you are a threat?
Yes, I am.
Okay. Well, I don't know how you mean that, but okay. What did I lie to you about? I'm not playing with
I
you.
don't trust women for a reason, bro. Hey, for real.
I don't trust people that don't listen to me. I've never given them. Look, how are you gonna tell me we made peace and then start being mean
No, I'm
again?
just letting you know.
I'm just letting you know who I am. It ain't no threat, not my good.
You kind of just threatened me, but that's
Okay,
cool.
you want to, I'm sure none of it. Feelings don't feel up here, something. Fuck feelings. That's what involved the whole array, it's your feelings.
All right.
That's your record.
You say something really spicy? I don't have a problem over here.
What?
You still go through, you still put it in a supplement?
Who's the sergeant in charge, man?
It's Gonzalez.
Is it the light skin dude?
Huh?
Is he light skin? I call him light skin, okay.
You look like you're like creeping up here, like you didn't know what you were walking into.
I'm gonna put my head in the
You looked a little scared.
Never scared. I'm not, for sure. For sure. I'm gonna play it again.
Nobody else. I see it. It's fucking hurting.
If he's been arrested,
Mr. Vaughn.
we have not received him as a disability yet.
You can take those off.
Gonna do it.
I would just try calling back in about 30 minutes to an hour. We won't know really anything
Mr.
about
Vaughn,
it.
I gotta leave.
Lindsay, if that's your real name, you know why it is. I done told you I'm fucking
Have more
with her.
information. If you do know what it is.
Take the cuffs off.
She's not in charge of this, I know that's it.
I need my.
Sergeant!
Get this fucking guy.
She's not none of that. Don't touch me, I know the sergeant is here.
I'm leaving. I ain't gonna shit tonight, so.
Yeah, you can call them. None of them are good right, and they might have some information to give you, but otherwise, I would just call back in about a half hour.
Oh, my.
All right, listen, I'm just talking about, listen, you won't be cordial, we'll be frank.
Well, because that's my stuff. I need my
I
stuff.
don't trust her.
That's her cups.
Bro, I will put myself in your custody and we can go to this cell together. She needs to be away from me. I'm asking you not to take these cuffs off.
Mr.
Until
Vaughn,
I get away from her. Me and you can walk over there. You tell her to leave me alone. I'm not gonna
however
cause
you
you
want to do
any
it.
trouble.
I
Fuck
just
the
need this
rest.
shit so I can go.
Fuck the rest.
I need to.
Play with me if you want to and find out.
I'm sorry.
Go ahead and get the keys. No, you're not gonna move. I'm gonna remove these cuffs off you. Stop pulling back now.
Pull it back. Why is she touching me? A female shouldn't be touching me.
now!
A female shouldn't be touching me, bro. Look, I'm scared. I'm in fear for my life. She should not be touching me.
Hey,
Alright?
nobody wants to hurt you.
Why is she touching me? I don't trust her. Get her off of me.
I hear you.
Please get her off of me.
Nobody wants to hurt you, just go with the flow.
Go with the flow. Get her off of me. I don't need her touching me. Y'all can handle me. I said I wouldn't.
Nobody's touching you anymore.
Stop pulling back
She
now!
fucking touch me.
She's not touching you!
She fucking touch me.
She's not touching you right now.
She's not touching you anymore.
Not touching me.
Relax,
She's not touching you.
relax.
Her hands are off you right now.
I just told you I would keep it. I'm gonna give you no problem. She ain't got no goddamn reason to touch me. When our dog get broke, it's your fault. You don't fuck about the law.
Sorry. Hey, we're trying to get the cuffs off you. Can you stop tensing up, please?
Fuck no, because I'm gonna beat that bitch up. Dead on it.
Thank
Y'all think everybody playing? You laughing. You live in this and family and talk somewhere. We get some problems. We will shake it up here.
I'm sorry. He just wants to act bad since he's in here. He's perfectly fine the rest of the time. Just trying to act hard. Here's his copies right here. That's all he had, was just whatever was on.
Just shoes.
That's all he had. Didn't have anything else. Original call for domestic. He was threatening to kill his kid.
Judge, we have stopped play at 22 hours, 37 minutes, and 59 seconds.
All right.
Judge, I am going to keep this queued up in case during his cross-examination, the defendant wants to play any portion of this.
All right, then we'll turn the lights on.
Did this interaction at the jail happen in Dixon County?
Yes, ma'am.
Did you have you had any interaction with the defendant outside of your capacity as a law enforcement officer?
No, ma'am.
These comments taken as a whole, did you mention this to another officer?
Yes, ma'am.
And that officer encouraged you to document these?
Yes, ma'am.
Why did he encourage you to document these?
He encouraged me to document the information.
Objection, Your Honor, speculation.
Overruled.
Why did he encourage you to document these?
He encouraged me to document it in my report just in case any further action happened, as if he did try to retaliate against me, did try to assault me or anything like that. Say if I, saw him out in public somewhere.
Let's talk about assault. You did not seek charges for him on assault that night.
That's correct.
And that's because he didn't hit you that night.
Yes, ma'am.
And that is a different legal charge than the retaliation.
Yes, ma'am.
Objection, Your Honor, leading.
Sustained. Don't lead the witness.
The charges of assault and retaliation, do those have separate elements?
Yes, ma'am.
Nothing further.
Mr. Vaughn, do you have the right to cross-examine the witness? Do you wish to ask any questions?
Yes, sir, I do. Just take it off. Good afternoon. Is it Corporal Jarvins?
Javins.
Javins, sorry about that. Is this this is a testimony you wrote, correct?
That is, yes, sir.
Here,
That
she'll
is-
read it.
I wouldn't say it's a testimony, but it's what I wrote, yes.
Okay. This was because the video was, it was difficult for you to hear, correct? The reason you wrote this?
I wrote it out for myself, and then I shared it with Miss Bryson, or General Bryson, sorry.
So you needed to recall it better for the jury, correct? Yes.
No, sir, I remembered what happened.
Okay. You, how long ago was this?
In 2022.
Okay, you remember what happened. Are you sure you didn't just write this out because you forgot what happened and you just wanted to, so I'm sorry, excuse me. I'm brain farting here, I'm sorry.
Okay.
So, you wrote this out so that you wouldn't forget what happened for the jury, right, correct?
I wrote it out while I was reviewing my video. I think that it's important that I did that because there were a lot of direct statements that were made that I think the accuracy is important.
Okay, so you remember it from the video or you have firsthand knowledge?
Yes, sir, from the video.
Oh, okay. So you only remember the threat and for retaliation from the video? Or, I mean, because let me ask you this instead. So you arrested me for retaliation. No, you didn't. I was charged with retaliation, correct? Retaliation and past act.
Yes, sir, that was presented to a grand jury and it came back with true bill.
So that wasn't the original charge, was it? That the reason I was arrested and taken to the jail, was it?
No, you were taken to jail for a different reason.
Okay. And you didn't charge me that night with retaliation or past act, correct?
No, sir.
Okay. Did I tell you that I was scared of women at any time during the traffic stop?
Yes, sir.
I did. Did you believe that to be true?
Not entirely, no, sir.
Oh, so you took it as joking or lying per se?
I didn't believe that you were scared of all women, no, sir.
Okay. Was there another female jailer present who had her hands on me at the time when these statements were made? When they were trying to remove the cuffs?
Yes, sir. Yes, sir.
And you didn't never hear me say your name at all or direct that towards you, that I want to do anything to you?
You looked at me and you said, Lindsay, if that's what your name is, because you were upset because you thought I lied to you. And then during that time, that between the two threats of breaking my jaw and beating me up, you called me a lying ass hoe or lying ass bitch, one of the two.
Okay. Your Honor, can I ask my question, please?
You may consult. Ladies and gentlemen, for further explanation, Mr. Spratt was appointed by this court as advisory counsel. He is not participating on an active basis, but he's there to give advice because of the fact that Mr. Vaughn had requested to be able to represent himself. So.
Okay, in the video we just watched, I'm sorry, your name is Miss Jarvin. Sorry, Jarvin, you got to keep forgiving me for that. I'm horrible with names.
You're fine. Last name is Javens.
Javens, okay. The video we just watched, you said he's trying to act bad because he was in there before and he was perfectly fine the whole time. You said that, right?
At the end, I made a comment that you were acting different than you were before we got to the jail. Absolutely.
You were laughing too also, right?
Yes, sir.
Okay. So felt no threat at the time at all that night, did you?
Threats were made to me, yes.
So you didn't feel threatened,
I did feel threatened.
but you're laughing feeling threatened?
I think that a part of my job, we are frequently faced with fear that we don't show. I've been faced with life and death situations and I didn't show fear.
So you had no threats or interactions with me since then?
The only interaction I've had with you since then is in court.
I think this would be safe to say that I feel like these charges were a retaliation from you instead of from me due to the fact that you arrested me for illegally. Would you agree?
Mr. Vaughn, you are making a statement rather than asking a question. It has to be in the form of a question. You'll be allowed to testify if you choose to do so, but this must be in the form of a question for this witness.
Okay. Would you say that the original arrest was illegal?
No, sir.
Let me see here. I got some more questions for you. What was your original charges you arrested me for?
Originally, you were charged with resisting arrest, stop, halt, frisk.
Hold on just a second, please. Ladies and gentlemen, step across the way, please. Okay, we're walking a fine line. You've asked her a question about the original arrests. The original arrests were for driving on a revoked license, third offense, and for the second count, which the court, I think, state resisting arrest, which I think the state acknowledged. My concern is that opening the door to the evidence coming in about you're having two prior, being driving on a revoked license, third offense. And that's why I wanted to caution Corporal, I just want you, if you can answer his question about driving on a revoked license, just don't add the third offense part.
Okay.
Is that
Yes,
all
sir.
right?
Yes, sir.
All right. Then that's the only thing. Any objection to any of that? Step back and talk to your advisory council. These are in my laptop. Let me step off the bench for a second. Mr. Spratt, I'm going to give you some leeway and from these, but I'm not going to keep delaying this trial for you two to confer. So make it quick. Understand, and that's why I'm simply advising you both. I'll give you an opportunity to consult. That's what elbow counsel or advisory counsel does. But there is a point where it's delaying the trial, and we're not going to continue to allow that to keep happening if it's going to be. That's fine. As I say, I'm not complaining. I'm just saying it's already almost 2:30 in the afternoon. So, what happened to our district attorney? All right, gentlemen, we're ready for the jury.
Yes, Judge.
Bring the jury in.
Excuse me, Your Honor, 1 second. I'm aware of the charges that I'm being charged with, and I don't want to hinder her from responding to my questions. I mean, they're going to have to know that what I'm arrested for anyways.
It's your decision as to how you ask. I'm just wanted to make clear that what you're opening the door for, and you go for it. You ask whatever questions you feel like you want. You've got counsel that's advised you, and now you're ready to go. I just was trying to take a head count. All right, I guess I could just count the empty chairs instead of the heads. All right, Mr. Vaughn, we are ready for you to continue your line of questioning.
Okay. What was the original reason you arrested me?
Resisting and driving on revoked.
Okay. Was was one of those charges dismissed?
The state elected to not proceed forward with one of them, yes.
Okay. Do you believe that I really was resisting that night?
Yes, sir.
Okay. Ron, I would like to play some video footage.
Briefly.
Sir?
If you need to consult, is that what you're saying?
No, I'm gonna play some video
Oh,
footage.
you want to play the video?
Yes, sir.
All right. Mr. Spratt can assist you in that. So are you going to ask this witness, what is it we're watching so that the jury understands and can follow along?
This right here, jury, is the beginning of the interaction with Miss Javins. I can't get it right.
Right. So you're going to show the body cam footage from the initial contact between you and Corporal Javins?
Yes, sir.
All right.
Judge, for the appellate record, this is the first file on the disk that is submitted as Exhibit 1. And we are starting at the beginning of play, and I'll note the time whenever they stop.
All right. Thank you.
All right, we're pulling into Delaware Junior now. Hello.
What are you doing?
Good. How about I come back here and talk to me real quick, man?
I'm not stepping out of the vehicle until you tell me the reason.
Well, we got a call that there's a domestic, so I just want to talk
A
to you about
call
what's
for a
going.
domestic,
Yeah.
what makes a domestic?
I got you. Somebody just called. Let me come back here and talk to me real quick. We'll talk about
I
it.
can't step out of the vehicle until I
You
committed a crime.
can't.
I reserve all my rights.
All right, well, let me tell you this. So Pennsylvania versus Mims, case law says anytime I tell you to step out of the car, you step
But
out
I
of the
know,
car.
but you also know. that,
Case
like,
law says,
hold on,
no.
I'm gonna
Case
teach
law
you.
says if I tell you to get out of the car, you get out of the car.
Can I have a
So
male, can
get
I
out
have
of the
supervisor
car.
come to the?
Well, they're coming. You're gonna get out of the car when I ask you
don't feel comfortable
to.
right now because as a female president, it's a male domestic. I've been in this
I'm
three
not,
times.
I'm just trying to talk to you.
Okay.
You're making this a thing.
No, I'm not.
Step it up for me. I don't want to talk to you. I want to talk to you separately, okay? That's how I want to do it. That's how we do domestics. We're going to talk to you separately. That's how we're going to go. So I'm going to get you to step out of the car. Look, this is
Am I
your
under
one
arrest?
You're going to step out because I'm telling you to step out now.
Where am I gonna stand, and am I under arrest
Step it
before I
up
step
for
out of
me.
my private vehicle?
You're not under arrest right now. I just need to
Then I
talk to
have
you.
no reason to step out. I'm still not under arrest.
Step out. You're going to go to jail for resisting.
I asked
The
you-
second I put my hands on you and you don't get out of this
I
car,
asked you
you're
a
going to
question.
go
You
for
did not answer
resisting.
correctly. You know this.
There ain't nothing about it. I just
If
told
I'm
you.
not under
I
arrest,
just
then you
told
have no
you.
reason to touch me.
Case law says if I tell you to get out of the
It's
car,
not
you
about
get out of the car.
touching. If you say I'm
It
under
is.
arrest,
Get out of the car. Come on. Get out of the car. Get out of the car. I told you to get out. Get out of the car.
Don't get out. Don't.
Get out.
Wait, hold on. Grab that before you
You're
touch
good.
me.
That's
You're
our
good.
work knife.
Ain't worried about that. Come back here and talk to me. Stop making this a thing.
Is that a male in that car?
Yes, there's two males in that car.
Look, I want a
Go
male
up
to
here.
touch me. Please stop touching me.
Go up here. Go up here.
I want a male to touch me.
Yeah, there's going to be a male that's going to touch you. Put your hands on
Male,
your back.
please touch me. A
There's
male,
going to
please
be a
touch
male
me.
that's going to touch
A
you.
male, please touch me.
All right.
There are no females to touch me.
Dude, chill out.
See, you're being disrespectful.
You've been disrespectful since
I asked you, am I under arrest? You said no. It ain't no shut up. Am I under arrest? And you said no. Then why am I
Did I
detained?
tell you to get out of the car? Did I tell you to get out of the car?
Am I under
Get
arrest?
out.
Am I under arrest?
Did I tell you? Now you are.
I reserved
Now you
on my
are.
arrest.
Now you're going for resisting at minimum because I told you to get out of the car. You didn't get out of the freaking car. How many times did I tell you to get out of the car?
No, you're not.
No, he's not. No, you're not.
Right now, I think you should go.
All right, ma'am. You step out and talk me away from the kids, please.
Yeah, we were just arguing.
I got
We've been
you.
together 15 years.
I got you. Well, there's enough that's already. Listen.
There's lights on too.
For the record, we have stopped at time signature 20:53:54.
Okay, are you familiar with the de-escalation process?
The de-escalation process.
Process or policy, yes.
I'm not sure what you're asking.
Do your department have a de-escalation process or policy?
We're trained on de-escalation, yes.
Okay, would you give me some idea what that looks like, or from your training? What did they teach you how to de-escalate a situation?
It varies upon circumstances and what's going on. I think that talking to people, I feel like it's a de-escalation tactic of talking to people like, hey man, come out here and talk to me real quick so we can talk about what's going on. That explaining to people their legal obligation to do something and giving them prior warning of, if I have to put my hands on you, you're going to jail for resisting. I think all of those things de-escalation works two ways. Gives that person a chance to begin to comply.
Okay. You just stated that citing their legal obligation to do something, correct?
Yes, sir.
So you cited Men's versus Pennsylvania, correct?
Pennsylvania versus Mims, yes, sir.
Okay, so you're familiar with that case law, correct?
Yes, sir.
But you're not familiar with pass act retaliation? That is a statute that you can charge somebody with?
What are you asking?
I believe earlier you stated that you didn't have knowledge of what the charge was, but you just took note of it in case something happened.
I took note of the threats. If you're referring to the last motion hearing that we had, when I said I was unaware that that was a thing, I was unaware that it was applicable to law enforcement. I didn't realize that we were covered under that statute. I thought that it was applicable for judges and DAs and things like that.
Yeah,
Or positions like that, I'm sorry.
Yeah, I'm sorry. I'm just finding it funny that you're familiar with case law, but not with it.
I'm sorry.
If we could keep to questions instead of statements.
You're making statements, Mr. Vaughn. Sustain the objection. You may only ask questions.
Okay. Let me see. Did I have a seatbelt on that night?
Yes, sir.
Did I have a knife or anything else on me?
Yes, sir.
Okay, did I give you the knife?
You told me the knife was in your pocket, and I took it out and put it in the car before you got out.
Do you think that was a wise thing for me to do? To let you know I had a weapon on me?
I appreciated that.
Okay, did that make you feel at ease? You wasn't feeling threatened any type of way?
I appreciated that you told me you had a knife on you so we could remove that from your pocket, yes.
Okay. When you're arresting someone, is it procedure for you to tell them to shut up?
Tell people to shut up.
Yeah.
I mean, it's not typically something that I do, but in the heat of the moment, I may say things that typically aren't said.
Okay, so the heat of moment, would you mean like you were agitated maybe?
I wouldn't say I was agitated. I was at a different level than somebody who would have complied and got out of the car and just sorted things out when I first asked them to.
Would you please elaborate on a different level, please?
A different level as in my senses were heightened that something else might be going on, that something's wrong. I have those officer safety concerns in mind because you weren't acting like the typical person does whenever you make a stop and you say, hey, come back here and talk to me for a minute. That's typically not the response that we get.
Okay. Oh, here's one more question. I think we asked this before, but just for the record, for the jury's ears too. What was the original call? What was your reason for pulling me over?
The original reason was for domestic. They called in and said that you were threatening to kill the female and the children. That person was so concerned about those threats, they even came to the scene to speak with me because she was so concerned.
Okay. I'll ask you next. And that's the charge you didn't charge me with, correct?
No, sir, you were not charged for domestic.
Okay. I have some more videos I want to play, Your Honor. We can move forward.
What videos are those?
I have actually off the same video. I got different parts of it I want to play for the jury.
All right. Mr. Pratt, are you
Yes,
going to assist you in that?
Yes, Your Honor, I believe he's got some marked, and I'll flow with him and let you know for the record where we're at.
All right.
So, Your Honor, for the record, we're starting back at 20:55 and 57 seconds. 20:55 and 57 seconds on the timestamp.
It's not besides the point when I'm in fear.
All right, man.
I'm in fear of females because look, in 2015, 5 females showed up to the scene.
Bro, come on now. Stop
Please
that.
let me speak.
Stop that.
You have
Stop
not been where
all
I've been.
that.
I don't know you. You're a new buddy.
Stop all
I'm not
that.
no disrespect to new buddy. I've been doing this for years.
Okay, so
No disrespect.
what happened at Walmart? Why are people
All I told her
calling?
was shut up. I got a phone call with people that are very dangerous telling me that my baby mama had her mouth open on their situation. I said, baby, you cannot talk. And she's still cussing me. She's doing everything. Look, shut up, shut up, shut up. All I repeat.
Yeah.
I've been with her for 15 years. She still ain't learned to shut up. I don't ever put my hands on her. I don't ever do anything. Look, I just bought that for her. It ain't even her birthday.
I didn't say you put your hands
I'm scared of females. I'm just gonna let you know because females make situations worse.
Oh, yeah.
That's why you heard me keep asking for
But it
help.
sounds like you made the situation worse by yourself whenever
No.
I told you to get out of the damn car.
But
and you
you're a
wouldn't get out of the
female.
car. Yeah, I tell you to get out of the car and you wouldn't get out of the car.
I will-
That's the bottom line. I explained to you. I explained to you the law. I explained to you. If I tell you to get out of the car.
Listen, man, when it comes to life,
That's a
law
problem
means
you
nothing.
think. Oh, I'm sorry.
When it comes
sorry
to
you
my
feel that way.
life, I'm sorry, but when it comes to my life,
Okay, and that's why you go to
I've
jail.
heard that before.
Okay, and that's how you go to jail. Is if you don't follow the rules, then you go to fucking jail.
Your Honor, for the record, we've stopped at 20:57 and 21 seconds.
All right.
Okay. My next question would All right, so would you consider this an investigation still into the domestic at this point in the video?
I had spoken to the female about the incident. I was attempting to speak to you about the incident, and if I'm not mistaken, it continues. And you said that, no, you just told her to shut up.
What I'm asking is this considered an investigation at this point in the video? This is what you're doing, correct?
Looking into the domestic, yes, sir.
Okay, all right, interrupting people while they're speaking, is that part of your training? Because you walked up in the video when I was talking and just start cutting
Judge,
people off.
again, questions, not statements.
The objection is to the fact that you're not asking questions, you're making statements. I sustain the objection.
Is interrupting people while they're speaking part of your training?
No.
Okay, I believe we just seen that in the video, correct?
Interrupting you from speaking to the other officers, is that what you're speaking of?
To them, including you?
No, that's not something that they train us on.
Okay. What about profane language?
No, they don't train us on that either.
I believe you just said in the video you're going to fucking jail, did you not?
I believe so.
Okay. What about the response? It doesn't matter what you think. Is this the proper response to people when you're investigating a domestic?
It doesn't matter what you think.
Yeah.
Six minutes, 31 seconds.
Oh, yeah, that was definitely in there.
I'm not 100% sure what that was in response to, sir.
I believe we can play the rest of that video now, Your Honor.
All right.
Your Honor, for the record, this will be from 20:58 and 20 seconds. Starting back.
All right.
So blunt splitter, what
Give it
is
to her,
that?
please.
Temporary.
Blunt splitter,
mat?
you see how that's disrespectful?
Yeah, what is that?
Charge me with
Entry
anything.
dog. Oh, it's
I
a
don't
splitter.
want to talk to you no more.
Okay, well, you're going to jail for resisting.
Resisting? I didn't do anything.
Did I tell you to get out of the car?
I told you I reserve my rights. I asked you the reason. That's my right.
Did I tell you to get out of the car? Did I? You
do not reserve
why
my
are you
right.
doing all that? Stand
I'm
up.
scared of you. I told you I'm scared.
Stand up. Quit acting like a grown man, man. Act like a grown man. Come on, come back here. You're making this a thing.
It is. If you've been beaten, you have to look in your life.
Yeah.
Let me fix
I've
this.
been where I've
What
been.
happened in the past is whatever.
It
We're here right now.
it's
and
all the same to me.
What am I gonna do? Beat the shit out of you?
I'm scared of you. I keep saying I'm scared of you.
You ain't scared of me.
I am.
You ain't scared of me, man. Come
I am.
on. You are not scared of me. Get in this car. Oh, shut up. You are not scared of me. Like, not even the slightest bit.
You can't change my words. You can take them and do whatever you want. I am scared of you.
All right, get in the car.
You're a female. I'm
Get in
scared.
the car.
Y'all make whatever y'all want to make.
Get in the car.
I'm with a white woman. I'm a black man. I'm scared of you.
That shit don't mean a damn thing to me. I don't give a shit about color. Get in the fucking car.
You don't, but I do.
Okay, get in
It's
the
my
car.
life. You ain't been where I've been.
Get in the car. All the way in.
I'm trying. Give
There
me
you go.
patience.
Cool. Yeah. Okay. Told him to get out of the car. Explained to him Pennsylvania versus Mims, everything. Told him to get out of the car. Told him to get out of the car. Told him to get out of the car. I had to open the door myself. And then I had to carry him out of the car because we didn't want to play games.
Roger that.
So she's not being.
She hasn't been cooperative. He's not being cooperative. He doesn't want my services for his domestics. So
She said at the beginning, I said, look, we got a call dude starting to kill people. She's like, he's just talking shit. He wouldn't really hurt anybody. And then near the end, I was like, so to be clear though, like he did threaten me. She was like, I don't remember him saying that. I'm like, okay.
Will you do my paperwork for me?
Your DV? Yeah.
I'm sure one of us, he got a wallet here or not. You got a wallet in here?
A wallet? No.
You don't have an ID?
I'm not 100% if it's in your.
What's that right there? Is that your ID? Oh, okay.
That's my license.
I got
I broke it a little.
What's his name?
His name, did he give it to you?
No, I haven't got it from you. He's terrified of females apparently, so.
What is his name?
What's his name?
Yeah. Okay, I'll go ask
Like,
him
I don't get
myself.
why you don't need.
I was just trying to get it from you because you're like a little more cooperative than he's being, so
I'm sorry about that. Like, I'm trying to, I don't want him to go
Is
to
it
jail.
what's tatted on your arm?
Stupid.
Because that's kind of funny.
Well, I don't want him to go to jail.
Okay, well, he's going either way,
So
so.
what's he going to jail for?
Can I see that real quick? I'll just use it by your
Yeah,
DL.
it's kind of broke.
For resisting, 'cause I told him to get out of the car, he didn't get out of the car. 46 Central, Tennessee D on ready. Will you try to get his info?
Yeah.
Thank you. 106-626-651. They're all good.
I lost her about 3 weeks one time.
Listen, I'm not trying to be rude, okay? I'm not trying to be rude at all. We were called. They're saying it's threatening to kill you and the kids and everything else.
Ask them. Hold on.
No, you're good.
Ask them.
No, we ain't gotta do all that. What I'm saying is, I'm here for a reason. Like, all I gotta do is make sure that he didn't beat the shit out of you.
No, I mean,
or beat
we're
the
not
shit out of the kids.
We're not bleeding. He can't even get back there to the
That's
kids
what I'm
because all this
saying.
shit and all. You
As
know?
long as that's not going on,
Like, no.
then I'll
He
give
ain't
y'all
put his
some.
hands on nobody. Yes, he talked shit. Yes, I talked shit.
That's
Yes,
what I'm
we
saying.
yelled. But he ain't put his hands on nobody.
It's not.
They're fine. We're fine.
It's not illegal to argue. Everyone argues. What I'm saying is, we don't have to make this a thing. Any type of situation like this, it doesn't matter who you are. I'm going to separate the people and talk to you. Okay? So that's all that was happening. That's why.
I think I went to school with you.
Yeah.
That's why.
When'd you
That's why we're here.
Okay, probably. That's what
Huh?
She doesn't have a tattoo on his arm.
She got him tell us who he is?
No, he will, but. So his name is actually Sherry. He pronounced it Cedric, and he spelled it like he didn't really give a fuck. Alright, so I was trying to copy it down while he was doing it, so I was asking if it's spelled Sherry. S-H-E-R-R.
You got a social? Just get a social. That's the easiest way. Go ahead, 146.
This thing started out as a joke, it's just got out of control now.
Careful. Did you get it? We get his social.
What's your date of birth? I can't look you up on that, that's why I'm asking.
Yeah, that works.
475.
That's your whole social?
475. 1250. Like when I take you upstairs.
You said that's way too many numbers.
No, 470. Ask her, she knows.
I know, that's what I'm trying to figure out, man.
She won't tell you who.
It's tatted on her arm, so it's not funny, but.
Which you shouldn't ask me, bro. Like, we have no games to play. There's no problem. She told you. I told
What
you.
is?
No. So just because that name's on her arm, though, right? That don't mean it's you, though.
I'm
It
telling
could
you
be
on record.
a different family member.
That is me.
Okay, I believe that. I'm just saying, when I first saw it, I'm thinking that could be a family member. I don't
All
know.
my kids and everything.
Okay, so, all right. So, what's your date of birth? We'll just do that. It's easier. You know when you were born, right?
I can't tell you how old I am because I don't celebrate birthdays.
2389. So you're 33. Because I'm 33. We're both 89. Yep.
Did you get all of that now?
61389.
Let me do DV real quick.
Is there some relevance to watching her pull out the paperwork that we need? Stop the video.
Yeah.
I mean, I understand it may be an hour or more that we're going through this. I'm just trying to determine, is there some portion of this that is relevant to the issues that the jury has to decide?
Yes, I have some questions that pertain to everything that's marked. It shouldn't be much longer. What is?
Your Honor, my list shows about 8 more minutes.
All right.
He's terrified of me, apparently.
Pretty intimidating.
Man's solid muscle. Not at all. He's like solid fucking muscle, man. Solid fucking muscle. Solid muscle.
That's probably.
That's different though, man. Come on.
Yeah. That's why it's very.
Yes, ma'am.
I'm the one who called.
Okay, yeah. Cool,
I
perfect.
even have my boyfriend on the phone who heard all of it.
Okay, what happened?
So you could tell she's pregnant, right? He pulls in absolutely just screaming at her over who knows what. But then he's like, I'm gonna kill you and those kids behind you. And then he was like, I'm gonna get my sister.
Where was this at?
So
I'm in the parking lot?
Yeah, on the worker's side. I don't have any doors behind you, so it's like I can hear everything and anything. But he's like, I'm gonna kill you, I'm gonna get my sister to kill you, I'm gonna drag these kids, I'm gonna kill kids. Talks about hitting her. Like, I even have my boyfriend on the phone too who can contest that he heard all of it too. He's talking about killing her and the kids and I don't know how to describe it, like pushing her kind of, like that nudge pushing her, and he was like slamming her and the doors on the car and like just going at her.
Okay.
But like, and didn't you hear all that?
Do you need TV paperwork?
I do, that's what I was trying to do. You'll get that.
But like,
I mean, I started.
my
just
boyfriend on the
hadn't
phone. He heard it all too.
I think she's gonna cooperate.
Yeah, but she got in the car, so it probably was a normal thing. But like,
Yeah, but she's not being very cooperative. Like she won't tell me much. So, and neither will he. So.
yeah, but yeah.
So he was like threatening to kill the kids.
No,
and
he was threatening to kill the kids. And like, I went and told my manager too, like what happened after I called y'all. But yeah, I saw the lights. I was like, that's probably them. So
yeah,
I
did get him stopped. So I do appreciate you calling.
but he was like threatening to kill.
Do you happen to have your ID on your second log that you were my complainant? And that I had like legit reason to make contact with him, you know? Yeah.
Yeah, but he was like going at her, and like, okay.
Sweet. I appreciate you calling for real.
Like, yeah, no, other people saw in the parking lot.
As far as like putting his hands on her, you just saw like he's kind of doing that, like
he was, like,
shoving,
nudging
pushing
on
her.
her. But then when they got in the car, you heard her scream, and then like they drove away past after that. And that's when I went inside to go tell my manager. If like a cop comes to talk to me, like y'all know that's not me.
Yeah. Yeah, that's
So like that shit was, he got like cruel to her.
What's phone number for you?
615-587-4057.
Cool. Yeah, the way it kind of sucks, like with domestics, that people don't want to like tell me what happened, and I didn't see it myself. I can't do too much about it. But yeah, he's going to jail for something else. So.
No, but yeah, I didn't know what to do because I didn't know like in the heat of the moment. It was like I'm right here, they're right there. He was like walking towards me and like kind of like are you listening type thing, and I was like ignoring him on the phone with my. I was like acting like I was talking to my friend. I was like, hey, I'm going home, I'm clocking out type thing.
Yeah, I got you. Well, cool. I appreciate you coming down here and talking to me real quick. You have a good one. Yeah. He was threatening to kill her. That was a complaint that just came down here.
Really?
Said that he was threatening to kill her and the kids. Like, she was like all shook up. She was like, he was like doing like that nudge kind of push thing, and they both got in the car together, and she started screaming, and then they drove off real fast. I don't really think that I have enough because she's not going to cooperate. She won't tell me of that.
You know what that is?
It's supposed to be a cap repair. When I first pulled it out, I thought it was a blunt splitter. That's what it felt like. That's what it looked like before the light was on. He's like, that's a kid.
Just terrified of it. Every time you keyed up, we couldn't hear what you're saying, and I'm like,
Probably because he was yelling over me. Yeah, sorry. I was asking y'all to step it up as I was trying to do, because like, as soon as I walked up there, he was...
We were all the way out on West Crab Creek, almost to Lena, to serve that warrant. And then I'm like, there's nobody else. So we were already coming priority, but we were so far out, it took a minute.
Yeah. I was trying to ask y'all to step it up, but because I didn't know y'all were coming hot. Already. Yeah, I didn't know y'all were still coming hot, but yeah, because I knew that was about to escalate. I expected him to whole lot start acting a fool. Well, I don't think she's gonna cooperate. So. Ask him if he wants his denture stuff or whatever this is. Did you want this going with you? Or you can put it in the car?
You want that stuff?
Your repair kit thing?
We'll take your silence as a no, so yes or no. Oh, so yeah, I was putting a...
Yeah, did you want this to go with you? Give it to her. Do you need anything else out of the car?
No, I want you to let me out.
Cool. There's that. He told me to just give it to you. It's like some kind of repair thing, something for tooth. Yeah. Cool, we do all that? Cool. You haven't read it yet?
No, I haven't.
Okay,
No,
so,
I read it. I was
yeah, we went over.
cool.
Like, I went over, I did have an ex-boyfriend that did, like, put his hands on me. Yeah, I got you. Look, I mean, like... It's been years ago, but damn, I cut my ear somehow. Who's this, man? I cut it at work yesterday. It's really stretched.
Oh, okay.
Oh, it's just I don't want to get blood on me. My thing is that I got people telling me a completely different story than what I'm being told by both of y'all, and that's cool.
I mean, I told you, you can ask them if he threatened to kill me and them, like.
Yeah, it's cool.
And I can't even get back there to him because they got a chicken.
I got you. Well, it's just so concerning about how aggressive he apparently was being with you. So, but if you don't want to cooperate,
I'm gonna be real, like right now I told him, if he did, it would be a totally different call. It wouldn't be a domestic, it would probably be a because I'm just not going.
Alright. Well,
I can handle myself.
I got you. Alright.
For the record, Your Honor, we just played continuously through to 21:13:59 seconds from the previous start time announced.
All right.
In this video you just seen, you said, stop making this a thing. What do you mean by stop making this a thing?
So you were making the situation into something it didn't need to be.
Would you say resisting, arresting me for a false resisting arrest, be making it a thing?
What are you asking?
Arresting me falsely for resisting arrest, would that be making it a thing?
I didn't falsely arrest you for resisting arrest. Probable cause was found on several occasions, actually.
Would it be making it a thing to arrest someone and not cite them when statute requires a citation?
A citation's not required for resisting arrest.
So I could have continued the resisting arrest after a citation?
Is that a question?
Yes.
What's the question?
So I would have continued, the incident would have continued if you would have cited me
Cited you for what?
for resisting arrest?
We don't cite people for resisting arrest.
You stated to the arrest and the other officers that you called for backup, you had to drag me out of the vehicle. Did you had to drag me out of the vehicle?
Did I assist you out of the vehicle? Yes, absolutely. You can see where I'm holding pressure on your arm to get you out of the car. And you're holding up on several times and you jerked away from me at the beginning and it wasn't to take your seatbelt off.
So it wasn't to point out a knife on me or anything like that or take the seatbelt off? That's what you're saying?
So I grabbed your arm and you pulled your arm away from me. Then you placed the cigarette in your mouth. Then you decided to take take the seatbelt off. And then you started getting out. You were hesitant. I'm pulling on your arm. And that's when you were like, hold on, I have a knife in my pocket. And I took the knife out of your pocket. And then you got out of the car. We began walking back to the car. I was holding your arm and you again jerked to put your hands in the air when you were asking if those were male officers that were arriving on scene.
But the resistance came for not getting out the car, correct? The resisting arrest charge came for not getting out of the car, correct?
Resisting arrest from the whole incident of not getting out of the car and me having to assist you out of the car, yes.
Okay. Okay, is separating me to address a domestic, is that your only method of addressing a domestic? Or was that your chosen method?
It was the method that I chose that made the most sense. You're the driver of the vehicle. That keeps you from driving the vehicle away with the potential victims in the car. I don't know what's in the car, if there were weapons in the car. I have all of these officer safety concerns due to your behavior and how you're responding to me and how you're acting. So the most reasonable thing would absolutely be to remove you and come talk to you instead of removing everyone else from the car because you didn't want to get out.
How many other people was in the vehicle?
Oh, you had children in the vehicle and she was in there.
Can you give me a count of how many people was in the vehicle?
I do not have a count of the number of people that were in the vehicle.
So you pulled me out the vehicle and you can't even remember how many people was in the vehicle?
Well, she was in the passenger seat, and then there was a huge aquarium in the typical area where someone would be sitting as the passengers, and then the kids were in the very, very back. I'm not sure the number of kids that were in the very, very back.
You sure there was nobody else in the vehicle?
Not that I observed.
So you secured the scene for your safety by pulling me out the vehicle, but then searched the rest of the vehicle?
Didn't search the rest of the vehicle.
You didn't want to see if there was anybody else back there, maybe some potential weapons in there, weapons of mass destruction, anything in the vehicle?
I separated the parties to investigate what was going on.
Okay. I mean, you were saying for officer safety, you took me out the vehicle, but I'm figuring officer safety is checking to see if there's any other harm in the area.
You're no longer in the car. You no longer have access to those things.
Oh, so I'm the only threat on the scene?
You were removed from the car so I could speak to you. You were the person that I was dealing with.
So as soon as you got to the scene, so it sounds like to me that I'm the person that you were targeting. Is this true?
Vaughn, you're making statements again.
I'm sorry, Your
You
Honor.
must-
I'm doing,
you
I'm
must
doing.
You must ask questions and not make statements.
Okay. So did you ever check the female on the scene? Did
Yes,
you?
sir.
You did?
Yes,
Did
sir.
You patted her down?
Oh, did I search her? You said
Yes.
checked. I thought you were asking if I checked her license. I'm sorry.
Oh, yes. Did you pat her down at any time?
I don't believe so.
Okay. You didn't feel the need to?
No, sir.
Okay. Did you check her driver's license?
Yes, sir.
Okay. What about the other witness? Did you check her driver's license?
What other witness?
The witness that pulled up at the back of your vehicle.
Judge, at this point, I'm going to object to relevance.
Sustained, that's not relevant.
The relevance being that I was also arrested for driving on revoked, Your Honor. And
And how is checking the license of the person who came to the scene relevant to whether or not you were charged with driving on a revoked license?
because it seems like I'm the only person that got checked for anything at this scene, Your Honor.
Right. Well, I am sustaining the objection as to relevance. In this court's opinion, it is not relevant whether or not they checked the driver's license of the person who came to the scene.
Okay. Okay, you said there was some other people at the scene. Did you say they were victims, I believe? That where threats was made towards them, so well, I don't know what you call them, but there was other people at the scene, correct, that threats was made towards?
Yes, sir.
Okay, did you have a question them?
It's my understanding they were children. Typically don't ask questions of children. It's already, traumatizing to a kid that's dealing with police in general. We've had this whole ordeal at the car of you getting out. I did not see it necessary to have this discussion with the children. I spoke to the female who was the other party who was supposed to be being threatened.
Is that procedure, not question children, or that was your own opinion?
It varies on the situation of their age. A lot of things go into play. A lot of times we do not question children.
What would you say their ages are?
I don't know their ages.
You never spoke to them at all, did you?
I didn't speak to the children. I said that.
Okay. So teenagers, do you think they're old enough to be questioned?
Judge, I'm again going to object to relevance.
Sustained, it's not relevant. You were not charged with domestic violence, and as a result of that, a lot of this information that you're going to is not relevant to the charge that's being tried. The jury is only considering the retaliation for past action charge. So you might want to focus on that. So.
Yeah, I believe I am, Your Honor. I just don't think I'm asking the questions the right way. It all stems to run together. I'm just trying to prove that I was targeted in a matter that nobody else was, Your Honor. Okay, in the video, you also said to the witness that came to the scene, you said, that's why this sucks about domestics. People don't tell me what happened, and I can't do nothing about it because I didn't see it. What do you mean by do nothing about it? What do you mean by that?
Well, the witness came to the scene and she obviously was concerned about what she observed. And I was explaining to her that sometimes victims of domestics, if those threats were made, for her to feel that uncomfortable to call police and show up to the scene, sometimes, if that all happened, sometimes the victims of domestic violence are not cooperated. they don't cooperate well whenever law enforcement come to the scene. So, yes, it sucks for that victim or for that person who may need protection if they aren't cooperative with us for us to help them.
Okay, would you believe that the witness was very credible?
Yes.
Okay, the passenger in my vehicle, would you say she was pregnant?
I don't know if she was pregnant.
Okay.
Judge, I'm going to object again to relevance to this whole line of questions.
What is the relevance, Mr. Vaughn?
Just to challenge her observation of the whole scene, just to show that, once again, she was just only focused on me at the scene. She wasn't really investigating nothing, Your Honor. She had a whole objective of just wanting to charge me because I made her mad, Your Honor.
Well, I am sustaining the objection because whether or not the passenger in your vehicle was pregnant or not pregnant was not relevant to the proceeding to the issue that we're dealing with and the charge we're dealing with. Sustain the objection.
Okay. Was there a witness statement made by the witness?
No.
Okay.
Judge, I'm again going to object to relevance. The investigation of the domestic, he is not charged with domestic. He has played the video. The jury can look at it as they want. There's just no relevance to this line of questions.
Sustain the objection.
Okay, let's go back to the video that Ms. Danny played for us earlier. You stated that you was assisting me to place me in a cell. This be acting outside the scope of your duties?
I wasn't assisting to place you in a cell. I assisted the other officer. They were trying to remove handcuffs from you, and only one arm was being secured by the other officer. Your right arm was not secured at all. So if you take those handcuffs off, both hands are free, and now we have an arm that's not secured. I'm not going to put anybody else in a situation to put anybody else in danger.
So, to put someone in danger, would you say you were the one creating the situation?
No, sir.
You have it was a body cam footage we seen, correct?
Yes, sir.
So it wouldn't show your face remarks or your smirking or anything else you're doing, correct?
No, you wouldn't be able to see my face.
Are you familiar with the jail policy for de-escalation?
I don't work for the jail.
Oh, you don't work for the jail, but you assist them at free will?
I never stop being a law enforcement officer. I'm not going to let them be in a situation where they're placed in danger. Removing handcuffs where only one arm is secured, that's unreasonable.
So when you enter into the jail and you place me in their custody, does your custody end there?
You go into their custody, yes.
So I go into their authority, correct?
You go into their custody. You are booked into the jail and you're in their custody.
Okay. So you said you're not familiar with your policy doesn't say anything about your authority ending when you place me into the jailer's custody? Your policy for de-escalation or enter into a penal facility or nothing? That it doesn't say anything about your authority ending once you place me into their authority?
I'm not sure what you're asking as far as that goes. I still feel obligated to assist if officers are being placed in an unsafe situation, yes.
Okay, so let me ask you this. Does your policy state that the only time that you assist in a situation in the jail is with their requests, that you just don't jump into nothing like that?
I don't believe our policy clarifies, but if it did, I would argue that I'm not going to place other officers in unsafe situations.
But with you present at the scene, and you seem to be the problem that how are you placing officers in a situation by just stepping back and stepping away?
You were making the situation a thing by escalating the situation because you would not let them remove the handcuffs. And then they were going to remove handcuffs and we were going to have an arm that wasn't secured. That seems like an officer safety issue to me.
So I did not pull away until your hands touched me, correct?
If I recall correctly, you were walking towards me, staring me down when Officer Gonzalez or Deputy Gonzalez grabbed your arm and pulled you back.
I don't believe I was freely, I can't say that. Um, um, the statement you have in your printout here that you typed, you said, on page 1, it states that, right after you told me your name was Lindsay, you said, I just gave you respect. I'm taking it back is what you said I said. You say I was joking or being serious at that moment?
I felt like at that time we were still on okay terms until we started the following statements that were made.
All right, what about when you said, what about when I stated, no, I'm just letting you know, I'm just letting you know who I am. It ain't no threat or nothing like that. You said, you kind of just threatened me, but it's cool. What did you mean by that? It's cool.
You can threaten me if you want to threaten me. Like, if that's what you want to say, you can say that. But I'm not saying that it wasn't a threat, because it was still a threat.
So did you take it as a threat, or did you saying it's cool because I ain't taking it as a threat?
The statement is a threat.
How did you take it?
I took it as you were saying, I am a threat for a reason.
But did you take it as a threat? Like, was you in fear?
I think where the separation between a threat being made and an assault is the threat was made, not like an actual action happened. At that point in time, like, yes, kind of concerning that you said that, then with preceding statements added on top of that.
Let me ask you this. Was there a reason to be alarmed at that point?
I was caught off guard while you started talking about being a threat because we had been having normal, reasonable conversation before that.
Do you recall in the video where right before you went off and started to print off your paperwork, that a jailer asked me, said, "You look scared." Do you recall that? Do you think, well, let me ask you the question. Do you recall that?
The comment about you being scared?
Yeah, a jailer said that I look scared in the video.
No, one of the other deputies were talking in the background to the nurse that was there and said something to the effect of, you look like you didn't know what you just walked into. She was speaking to the nurse that had just walked up from the jail.
No, she was actually speaking to me, but your paper, well, I can't make that. I'm trying to explain the situation, Your Honor. Your paper was actually up a little bit in the video. You couldn't see me respond, but I responded to them. Did you take that, you stated, well, you answered that statement. I was going to ask you next. Did you think that statement was serious or false? I believe the last questions I have for you right now would be, towards the end of the video, you said, you're laughing, you live in Dixon Fairview, you talk too much. And you started laughing. Why were you laughing?
I'm not going to say, oh no, I'm so scared because you are implying that you know where I live. I'm not going to show fear in that situation.
Did you actually charge me with retaliation of past act?
It was presented to the grand jury. I did not obtain warrants for that charge, no, sir.
What was it? How many months away was that, like after the arrest? Would you know?
I'm not positive on the length of time.
Say about 5 months after the arrest.
I don't know the exact amount of time, but if
During that 5 months, did you receive any threats or run-ins with me or have any issues after that?
as I previously stated, I've only had contact with you during this encounter and in court.
Okay. Do you think it was necessary to put a past act retaliation on me after 5 months and no issues?
I think that it was applicable in the situation. Threats were made to me in the capacity of a law enforcement officer for doing my job.
Okay. So you don't think it was just retaliation for the false arrest?
There was no false arrest.
Okay. So you felt the charge was necessary to be placed on me?
Absolutely.
Okay. Thank you, Your Honor. Thank you.
They have any redirect?
Corporal Javens, to be crystal clear, the person that we heard in that video making those statements to you that you identified as threats, was that the defendant, Sharik Vaughn?
Yes, ma'am.
Could you point to him for the record, please?
Yes, ma'am. He's over here. Black shirt, red tie.
Judge, if the record would reflect that she has
The
identified the
record will reflect she has identified the defendant.
couple of things from the video that the jury has watched. Did you let the defendant smoke a cigarette after he was already under arrest?
He continued smoking the cigarette after we walked back.
So you let him keep it, you didn't take it away from him?
No, ma'am.
And you tried to bring him something in a small container. What was that?
I believe it was something for his tooth. It was some type of, I think he had an issue with his tooth and it was something for that.
And the defendant's attitude from the beginning of the interaction, it goes up and is sort of elevated, agitated. And then we see him calm down. Does he ever get agitated
Objection,
again?
Your Honor, leading.
I don't think she's finished the question. I think she's giving a prefatory statement before she gets to the question part, but let me hear the rest of it and I'll consider your objection.
Does the defendant ever get agitated again like he is in the beginning before the interaction in the jail?
Overrule the objection. The statement she made was prefatory in nature to describe what she was going to ask.
Do we ever see him, or did you ever see him get agitated again other than what we see at the jail?
No, ma'am.
So we see moments of almost joking conversation between you and the defendant and other officers and the defendant.
Yes, ma'am. After the initial coming back, after he was in the car, the demeanor was completely different until we walked into the jail. We got into the side port.
I have nothing further, Judge.
Well, thank you, officer. You may step down. They may call your next witness.
Judge, I believe there is a jury out matter before the next witness.
Ladies and gentlemen, if you'll step across the hallway, let me consider whatever this issue is, please. Officer. All right, what is the issue?
This is for Corporal Stewart, our next witness. Make motion to exclude regarding statements pursuant to Tennessee's rules of evidence 403, probative value substantially outweighs the prejudice effect. And I was in custody with no ability to carry out the threats. The statements was not made specifically at Jarvin's, who was having victims in the indictment, who was named victim in the indictment, is not relevant to any fact about Jarvin's more or less true. So object to Rule 401 and 402.
You're objecting to the testimony of this of the witness who made the statements that, or repeated at a hearing earlier, that you had said you had a bullet for all of you or something on that order?
Yes, sir. I mean, he also testified that he didn't witness me state anybody's name. He just made an assumption that it was for all in law enforcement. There's no relevance to the statements.
So are you objecting to relevance, or are you objecting under the rule that exclude, I'm assuming you're looking at other, the rule of evidence having to do with other bad acts?
The Rule 401 and Rule 402, Your Honor.
All right, let me hear from the state.
Judge, I have a good faith belief that the officer's testimony will be that not only did he hear these statements, they were an hour and a half to 2 hours after the arrest and after the after Javins would have left the jail. It shows not only a continuation of the anger directed at Javins and other officers, but that continued anger shows that there may be an actual intent to carry it out, because once Javins was removed from the jail and removed from his presence, he was still making threats to harm law enforcement. And they distinctly go hand in hand with the threats that he had made earlier.
The objection is made under 401 and...
Say one more rule, Your Honor, 403. And the intent was never carried out, Your Honor, stated in these rules. It's not a factor in the naming offense, or the naming charge, Your Honor.
All right. Have a seat.
Yes, sir.
The objections are made under Rule 401, 403, and 404. 401 of the Rules of Evidence is the definition of relevant evidence. 403 is the exclusion of relevant evidence on the grounds of prejudice, confusion, or waste of time. Rule 404 is character evidence not admissible to prove conduct. There are certain exceptions, including other crimes. The court finds that the objection should be overruled because from the pretrial hearings that we had, the testimony of this witness is that he was dealing with the defendant at the jail, and that the defendant made statements that would indicate that he had intent to cause harm or made threats against other law enforcement, including possibly the corporal who testified in this case. My recollection was that he said, "I've got bullets for all of y'all." That, in my opinion, can be construed definitely as a threat, and that threat would factor into the definition of the crime for which he is on trial. So if the crime for which he is on trial constituted by threats, oral threats that are made, then those threats that are made constitute evidence of the crime itself, and therefore they are not evidence of other crimes, but rather are evidence of the crime for which he is standing trial. It is extremely relevant, and therefore the relevance, because it is the very nature of the charge for which he is on trial, the very relevance of those statements that would have been made to go prove beyond a reasonable doubt, if the jury so finds, outweighs any prejudice to the defendant. Clearly, any evidence of guilt can be prejudicial, but in this case, it is the fact that the statements that were made were part of the proof that the state intends to rely upon to prove that the defendant actually made a retaliation for past action threat. That definition that the jury has to find is that the defendant threatened to harm the alleged victim by an unlawful act, that the alleged victim had been a law enforcement, and that the defendant did so in retaliation for anything the law enforcement officer did in official capacity as a law enforcement officer, and that the defendant acted intentionally, knowingly, or recklessly. So clearly, statements made at the jail after the instance that we've seen that indicate that he has bullets, if that is the terminology, for all y'all, it is extremely relevant and is, while prejudicial, it is the prejudice is outweighed by the relevance, which goes to the very crime for which he is on trial. Therefore, the objection is noted, the record is preserved, and I overrule the objection. Now, you have this corporal. How many other witnesses do you have?
Lieutenant. He's a lieutenant. Only Lieutenant Stewart. No. Sergeant. Sergeant Stewart.
All right. My concern is whether or not we're going to be able to finish this trial today. I'm assuming we can move quickly through these next witnesses.
Judge, my proof with this witness should be about 10 minutes.
All right. Well, since the jury's out, let them have this as their afternoon recess, and we will come back. Let's make it about 10 minutes for us. Everybody that needs to take a restroom break, take a restroom break, and we'll come back and resume.
Stewie's up next. You cannot tell him anything.
You may call your next witness.
State calls Sergeant Justin Stewart.
Sorry, I do somewhere. Raise your right hand, let's place you under oath. You solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God. All right, thank you. Have a seat. Speak directly into that microphone, please.
Are you Sergeant Justin Stewart with the Dixon Police Department?
Yes, ma'am.
Would you spell your first and last name for our court reporter?
Yes, ma'am. First name Justin. Last name Steward. D as in David.
On June 18th, 2022, were you working in your capacity as law enforcement?
Yes, ma'am.
And you were actually out on scene assisting Javens at the original call.
Yes, ma'am.
And that was the first time that night that you saw the defendant.
Yes, ma'am.
Did you see him again that night?
Yes, ma'am.
Could you explain to the jury where you saw him and what got your attention?
Yes, ma'am. So, am I allowed to talk on the video that's been played? So, or did they see the whole thing? Or?
So let me walk you through a little bit more. So they're aware of what the call was about, but you, and let me just help you to the point that we're at. Did you go back to the jail later that night?
Yes.
Did you going back to the jail have anything to do with the defendant?
No, ma'am. In fact, what I was going to mention is that whenever she called for units to step it up, I was en route to another call for a warrant service. So once her call concluded, I then went to the call that I had told her about, and we made an arrest, and that's how I had contact with him again. So
the warrant service means someone has an outstanding warrant and you're going
Yes.
to serve it.
Yes.
Okay, so you serve that warrant, you take that person to the jail. What happens next?
So at the time, I believe I was still a corporal then. I had recruit Floyd with me. So whenever we have recruits that are in training with us, we kind of slow down some of the paperwork as far as, where originals go, where copies go, things like that, standard training things. So once we concluded business with the subject that I arrested, who was cooperative, we served his warrant, advised his court date, et cetera. We made copies of all paperwork, and then jail staff kind of took him away. Our business was concluded. So unfortunately, at that point, that's where we turn off our body cameras, right? And Mr. Vaughn was out in the, I guess you could call it the common area on the male side and booking, and was still upset and made a comment that he had bullets for all of us or something to that effect. And I simply mentioned to Corporal, I believe at the time, Javens, when we got back to the police department, she just needed to notate that in her report, just in case in the future, she were at Walmart or wherever, and he were to actually try to follow through with those threats. So.
When someone makes a threat like that, is it common for law enforcement to note it in your paperwork?
It should be.
And you said in case she sees him out in public. What do you mean?
I mean, if she's out with her family at Walmart or the movies or anything, and he actually intended to follow through on them and cause like harm to her, and she had to defend herself, we would have documentation that she wasn't just out looking for a conflict, that threats were made. And that's obviously something we take seriously, and I believe would put any of us on edge. So
Did his remarks put you on edge?
of course, yeah, it's always uncomfortable. That if not, I wouldn't have made it a point to go back and mention it to her that this is worth documenting. It's concerning. You're threatening, officers. And
to the best of your recollection, what were his words?
I believe that it was, I have bullets for all of you, or I have enough bullets for all of you. That's essentially what it was. So.
Nothing further, Judge. Well, actually, I'm sorry. About how much time would have elapsed between the end of Javens's call and when you were there?
When I returned to the jail?
Yes, when you returned and you heard these statements from the defendant.
So I can guesstimate, or if I'm allowed to use my phone, I can get the exact time.
A guesstimate is fine.
Maybe hour and a half, if I had to guess, ballpark.
So at least an hour, no more than 3 hours.
That sounds reasonable.
Thank you. Nothing further.
Mr. Vaughn, do you have questions for this witness?
Yes, sir. One moment, please. How are you doing?
Doing good. How are you?
Corporal Stewart.
Yes.
Oh,
Stewart.
Sergeant Stewart now.
That's all right. That's all right.
When you entered that jail that night, did you have your body cam on?
I would have whenever we entered with the other party that I had after the fact, if that's what you're asking about, the arrest warrant that I referenced.
Did you manually turn off your body cam?
Yes, once business is concluded with the person that we're interacting with, that's standard, yes.
Said you. And you testified previously that Corporal Javens was not specifically mentioned in these statements, correct?
That's correct.
Okay. And you were also on scene when I was arrested, correct?
Yes.
But you're not named as a victim here today, are you?
Yes.
I believe that'll be all, Your Honor.
Right. Any redirect?
No, Judge. May he be released?
Thank you, Sergeant. You step down and you are released. You can go about your business, or you may have a seat in the courtroom. Sorry, next witness.
That's the state's proof, Judge.
State has rested their proof, Mr. Vaughn. You need to consult with Mr. Spratt before we proceed.
Yes, 1 second, please, Your Honor. Your Honor, I believe we're going to need the jury out to take up some matters.
All right, ladies and gentlemen, I need to take up a matter quickly. If you'll step right across the way, hopefully this will not take long. All right. Mr. Vaughn, you have a matter you want to take up?
Yes, 1 second, Your Honor. I'm coming.
There were two final charges that weren't marked jury copies. Are they the same? Did you make any changes?
Well, that, and I knew they had to
That's
scan.
fine. I didn't count them, so. All right, let's take it up.
Per Rule 29 of Criminal Procedures, a motion for a judgment of acquittal, taking the facts into light most favorable to the state. No reasonable jury can conclude that I am guilty beyond a reasonable doubt of this charge. Your Honor, no statements were made directly to anybody. There's no harm that was done to anybody. To add insult to incident, 5 months delay, there was no carry out of these allegations of the statements I made. The intent was never there. And I believe with all the evidence that I showed to the jury, they would be acquitted, Your Honor.
All right, thank you. You wish to respond, General?
And in a light most favorable to the non-moving party, the jury has heard multiple statements that he was going to break a female's jaw, that he was going to beat a female up. All of these taken in relation and in the context of the situation means that they were directed at Officer Javins, and the jury could easily conclude that they are in retaliation for his arrest, which was done in her official capacity.
Motion for judgment of acquittal is a procedural issue where the defendant challenges the sufficiency of the evidence. And as Mr. Vaughn himself pointed out, I have to review the evidence in the light most favorable to the state, the non-moving party, and as a result of that, I find that there is ample evidence for the jury to find that the defendant has in fact committed the crime of retaliation for past action. All of the statements that have been alluded to and been introduced by the state could be interpreted. I think it's an argument that as far as the no harm, statute doesn't require harm. It requires a threat to be made against someone in law enforcement as retaliation for past action. And the argument can be made that, well, there was no present ability to carry it out and so forth, but the statute doesn't require that. So I find that there is sufficient evidence to overrule the motion. And now we move to the question of whether or not the defendant is going to put on any proof.
I think if we have a Momon hearing ready, I think he may call a witness, but I think he's going to make the decision not to testify.
I would rather talk with him and find out quickly whether or not his intentions are to testify. He should know by now, I would think.
He's not going to, Your Honor.
If he's not going to, then bring him around. Let's go ahead and do the Momon hearing. Mr. Vaughn, I'm going to ask you to be placed under oath for the limited purpose of us conducting this, what's called a Momon hearing, and that is where I question you about your intentions to, I'm going to go over it with you, and then if you'll raise your right hand, let the clerk place you under oath.
Fine.
All right, Mr. Vaughn, you are, understand, and I want to make sure you do understand, that you have a right to testify, in this trial on your own behalf. And if you want to testify, no one can stop you from testifying. Do you understand that?
Yes, sir.
You also understand that you don't have to testify. No one can make you testify against your will. And if you don't choose to testify, the jury cannot draw any inferences from the fact that you did not testify. And in fact, the burden remains on the state to prove your guilt beyond a reasonable doubt as they've been instructed, regardless of whether you put on any proof or call any witnesses or testify. Do you understand all that?
I understand.
Have you talked this over with your advisory counsel, Mr. Spratt, and discussed with him the advantages and disadvantages of whether or not you want to testify?
Yes, sir, I have.
And do you believe it's in your best interest to testify or not to testify?
I believe it's in my best interest not to testify, Your
All
Honor.
right. Then upon your decision not to testify, I'm going to ask you to sign this form. Mr. Spratt, I realize that you are advisory counsel, but I'm going to ask you to sign as advisory. All right, thank you. All right. I will.
Seen that come up in a 15-year-old CR later.
All right, then have a seat, Mr. Vaughn, and we're ready to, are you going to call any witnesses? All right, then we're ready for the jury. All right, ladies and gentlemen, the state has rested their proof. Mr. Vaughn, do you have a witness that you wish to call? All right, call your witness.
I'll call Jennifer Dozier.
You'll come around, please, ma'am, and raise your right hand and let the clerk place you under oath.
Yes, ma'am. Do you solemnly swear affirm that the testimony
Mr. Vaughn, you may question your witness.
One second, Your Honor. Just state your name for the record, please.
Jennifer Nicole Dozier,
How do you know me?
20 years and 3 kids.
Okay,
Pull
so,
that microphone towards you a little bit, please. There you go.
And we have 3 kids together.
are you familiar with this case here today?
Yes.
The initial call that the police were called for, are you familiar with that?
So we were arguing.
Yes. What did they say it was when I got to the scene?
We were arguing in Walmart.
Okay. Are you familiar with the statements that were made, the reason they came?
I don't remember. It's been years.
Well, the statements that were made were statements that I could cause harm to someone in the vehicles or to yourself. Do you believe that it was possible that I could cause harm to you?
No, not in that moment. We were arguing over a birthday cake.
Do you think I'm someone that should people be scared of?
No.
Would you think I'd be the type of person to retaliate on somebody or dwell on things?
Not to my knowledge. Not that I've seen you do in 20 years, but
One of the charges that I was arrested for was resisting arrest. I don't think that's a good question, but I'm gonna ask it. Do you believe I should have been charged with resisting arrest?
well, no, but that charge was dropped, correct?
Yes, it was.
So,
Do you believe I should have been charged with that? Do you feel like I resisted in any way?
no.
From your own knowledge, there was other people in the car, correct?
Children?
Are they well capable of speaking English and understanding English?
Yes.
Do you think that if they were in fear, that they would have spoken up if asked?
Yes.
You being their mother, do you believe my kids are in fear of me?
I mean, you're their father. They're supposed to be in fear of you at times, but
Okay. Do you think that they would think I would harm them?
no.
Do you believe that the arresting female officer on the scene, do you believe that she addressed the issues to the best of her authority, you think?
I think she did.
You think she did?
I think maybe she could have called a male officer, but they could have been shorthanded that night. We don't know what was going on.
Okay. I think that would be all, Your Honor.
All right. State, have any questions?
Judge, I'm going to need a jury out before we have questions.
Ladies and gentlemen, if you'll step out across the way, I will need to take up a matter in your absence. General, you may ask, or you may make your argument.
Judge, I am giving the court notice that I am about to go into prior bad act evidence by the defendant, asking this witness if he is capable of harm. He has opened the door to prior bad acts, including that he has previously been convicted of aggravated assault, aggravated robbery, a second aggravated assault, and a second aggravated robbery, if this witness knows that.
Yes, I am aware of that. I don't feel like
You just need to be quiet. I'm taking up lawyers are making a motion, so I'll have to be the one to deal with that. Door has been opened, not just open, but flung wide open and scotched open, it seems to me, by Mr. Vaughn when he asked the question about whether or not he would be the kind of person who would commit that type of an offense. So. Is advisory council.
I think it was State versus Wood that voting about that. Advisory council can be standby counsel. This could be a situation where I need to
The court rule is he elected to represent himself. And with that, as I asked him, if he had familiarized himself with the rules of evidence and so forth, then it becomes imperative on his behalf to make sure he's familiar with. And of course, he's quoted in the pleadings he filed that we had motions on, numerous cases, a lot of case law, a lot of rules. He's cited rules today. There's a line at which he's responsible for whatever he chooses to do. And he was advised he would be held to the same standard as a lawyer. Clearly, a lawyer who asked the questions that he asked about his client opened the door to the question of whether or not. Right now, the jury has heard this witness say, oh no, she doesn't think he's the kind of person who could do that kind of threat. That's a very material issue in the case having to do with a threat of retaliation for past action. The very gravamen of which is that he is capable of making that argument. So the state has the right to now produce evidence to show that this defendant, through this witness, is capable of such actions if he has in fact been convicted of other crimes. My intention is to allow this evidence to come in and to give the jury a limiting instruction. Their instruction will be that they are to consider this evidence only as it goes to the credibility of this witness's testimony regarding her belief that he is not capable of such, he does not pose a threat and is not capable of that type of action.
I understand the court's ruling.
No, we're moving forward. The reason is, it's not going to make any difference whether you have 5 minutes. You can sit there and have 5 minutes with him, but the fact of the matter is that we're moving forward with the questioning of this witness, and Mr. Vaughn you can consult with him, but it's not going to change my ruling. All right, General Bryson, question the witness as to what the question, ask the questions you're going to ask in front of this, in front of the jury of this witness.
Judge, while this will not be the full cross-examination, the pertinent questions will be, Ms. Dozier, are you familiar that the defendant was convicted of aggravated assault in November of 2016?
Yes.
Are you familiar that he was?
Objection, Your Honor. Basis knowledge.
We are having a hearing, Mr. Vaughn, and for me to determine, the jury's not here. We're having a hearing for me to determine whether or not this evidence should or should not come in. So you just sit quietly. I'll give you a chance to question, to make your argument, or through your counsel. I'll let you make the argument. Go ahead.
Are you aware that he was also convicted of 2 counts of aggravated robbery in 2016?
I am.
Are you aware that he was convicted of aggravated assault in 2011?
I am.
Those are the questions, Your Honor.
So you're asking her about convictions of the defendant for aggravated assault, aggravated robbery?
Yes, Judge, he has 2 convictions for each that are listed on his range notice and impeachment notice.
All right. Then your argument is on the admission of this evidence is what?
Judge, under Rule 404A, the character of the accused on a pertinent character trait offered by the accused may be rebutted by the prosecution. Judge, the defense having put forward that he is not capable of harm, these are crimes of violence which would directly rebut the evidence that he's put at issue.
All right. Mr. Vaughn, you wish to...
Your Honor, the questions that I were asking were pertaining to retaliation. And to the best of my knowledge, I believe she doesn't know nothing about the convictions of the defendants. I can ask her yourself for the record, Your Honor, if you want me to. Ms. Dozier,
No, we're not asking her any more questions.
Okay.
Now we're talking about the fact of whether or not this evidence should or should not be admitted. I'm giving you a chance to tell me why it shouldn't be admitted.
because the questions I was asking was pertaining to harm to the children and pertaining to retaliation of past acts. She doesn't have any knowledge of my convictions.
You ask her the question.
So
You ask her the question.
I'm asking her questions from the time that me and her was together at these charges, Your Honor. She doesn't have no true knowledge of them charges. Me and her wasn't even together when them charges happened, Your Honor.
Well, that may be, but she just testified on direct with General Bryson that she was aware of all of those convictions.
She wasn't given a copy of none of that. Yeah, I don't believe it should be used, Your Honor.
All right, thank you. Court is going to allow the state to ask the questions, and I will simply limit your question to, is she aware of the fact that he's been convicted of aggravated assault and aggravated robbery in the past, without going into the multiple counts of aggravated assault? I don't think there's any reason for doing that. I think you can establish what you're trying to establish by simply referring to his prior conviction, if she's aware of the fact that he has a prior conviction for that. I still intend to instruct the jury that I'm allowing this information over the objection of the defense for the sole purpose of testing the credibility of this witness and her testimony as to, in response to the questions the defendant himself had asked about whether or not she thought he was capable of these things. Bring the jury in. Outside of your presence, I considered an objection that was made to some testimony that was going to be offered. The state is about to ask some questions of this witness. I am allowing the state to ask questions that because of the fact that the defendant asked this witness questions about her belief as to whether or not he was capable. You'll remember what was the questions were, whether or not he was the kind of person that would have posed a threat and so forth. So the state is now seeking to rebut that testimony by offering questions of this witness regarding some other matters. I'm allowing it to be introduced solely for the purpose of testing the credibility of this witness on the issue on her testimony in response to the defendant's question. You should not consider the evidence you're about to hear on the issue of guilt or innocence per se, but only on the issue of the credibility of her testimony about whether or not he poses a threat or he posed a threat and so forth. So the state may now cross-examine the.
Ms. Dozier, you testified that you and the defendant have been together for 20 years?
On and off.
On and off. And you have 3 children together.
I do.
What are their ages?
17, 15, and 12.
And you testified that the defendant was not capable of harm. Just yes or no?
I did.
Okay. And you are aware that the defendant has previously been convicted of both aggravated assault.
Objection, Your Honor. Basis of knowledge, ask the witness to lay a foundation. Basis of knowledge, Your Honor.
Overruled.
You are aware that the defendant has been previously convicted of both aggravated assault and aggravated robbery.
I was where he's arrested on him. I didn't attend his court proceedings, but I knew he went to jail, of course, or prison. Excuse me.
Nothing further, Judge.
Redirect of this witness.
To the best of your knowledge, have I ever retaliated to anybody in these charges?
Not to my knowledge, no.
To the best of your knowledge, was any of them hurting any kids?
No.
Okay, thank you.
Thank you, ma'am. You may step down. You may have a seat in the courtroom or you may leave. Mr. Vaughn, you may call your next witness. Do you have any rebuttal proof?
No, Judge.
All right, ladies and gentlemen, you've heard all of the evidence that you are going to receive to be able to decide this case. The next step is for the lawyers or the state and Mr. Vaughn to make their closing argument. I would remind you that the closing arguments, both of the state and of Mr. Vaughn, are not evidence. They are not testimonial, they are not evidence, they are simply their argument to you about what they think the case has proven. So therefore, we'll let the state go first, and they have the right to go first, and also to close after the defendants.
Ladies and gentlemen, put before you today is to decide a very narrow set of facts, whether or not the defendant on June the 18th in 2022 knowingly threatened to harm Officer Lindsay Javens by any unlawful act in retaliation for anything Officer Lindsay Javens did in an official capacity. On that night, Officer Javens arrested the defendant and took him to the jail. When they got to the jail and you were able to listen to the video and you have the transcript from Officer Javens, it's up to you to decide what you think was said on that video. The transcript is an aid to help you. But the state would submit the following statements demonstrate very clearly that the defendant knowingly threatened Officer Javens for her arrest of him that night. I am a threat. I am a threat for a reason. Officer Javens will say, you kind of just threatened me, but it's cool. And the defendant says, you can take it anyhow you want to. I don't care about none of that. When they begin to take the cuffs off him, notice what he said. Don't take them off right now. Don't do it. He says, Lindsay, if that's your real name, you done lied to me. I done told you I don't trust women for a reason. Stop talking to me. As they begin to get the cuffs off of him, he says, when her jaw gets broke, it's your fault. Okay? He then screams, lion ass hoe. Okay, he's accused only one person of lying. That is the officer. That tells you who he is directing this tirade at. It's directed at her because he's decided that she's lied to him. He then says, and ladies and gentlemen, I'm going to use his words because those are his words that you saw in the video. The female says to him after he says lion ass hoe, the other female in the room says, hey, we are trying to get the cuffs off of you so you can stop tensing up, please. And Vaughn responds, fuck no, because I'm going to beat that bitch up. Bet on that. As he's going into the cell, he turns to this officer and tells you about something she already told you in their earlier conversation. He says, you laughing? You live in Dixon, Fairview, you talk too much. And then he continues on once he's placed in the cell. Ain't none of y'all safe without a goddamn badge. And then an hour and a half, 2 hours later, he is still speaking in the vein of these threats he's already made, as he says, where Corporal Stewart hears it, he's got enough bullets for all of you. Law enforcement should be able to do their job based on the facts and law in front of them and with no fear of retaliation for what they've done. That is why threats are enough. The officers told you they documented these because these statements might become relevant later on. That tells you the mental effect that these threats had on law enforcement. That tells you that they perceived them as serious, that they perceived the defendant could act on them. And under the law, it is the threat alone that is enough for punishment. Is everyone here very thankful that these threats were not acted on during that time span? Yes. But this isn't an assault charge. He doesn't have to have hit her in that moment. This is a charge for retaliation for past action, and it goes to the threat that were a direct response to her action as law enforcement.
With all the evidence that is shown here today, can we say that we're happy about what happened? No. Can we say that we believe that we should be charged with something like that? No. If the charge should be, I should be charged with something like that, I believe it should be immediate. I made bond probably 12 hours afterwards on the street, went and opened up a business. Actually had a first responders meal for $8 on a food truck. I build houses too in the community.
Judge, I'm sorry, the defendant has opted not to testify and is
Well,
stuck.
You can make an argument about what the testimony has been in this case and the interpretation of that testimony, but you cannot testify, which is what you're doing now. I sustain the objection. Jury will disregard.
Okay. Be honest, like, who hasn't cussed a police officer out before? You get pulled over for a ticket, whatever, I don't care what it is. They get on your nerves just like they get on my nerves. I'm an American. Did I do something? No. Did I speak in writing? That's debatable. It wasn't even direct. Throwing stuff out in the air, everybody in here probably said something. Every one of y'all should be charged with it, if you ask me. With the evidence provided you, I've also shown that if it wasn't for the fact I was even arrested in the first place for a charge that they chose to dismiss, a charge that y'all didn't even hear today, this charge wouldn't even been put on me in the first place. I've also took the charge of driving on revoke, which I had very good arguments for that. Documents I could have put in a day, but just to show y'all that I was being honest about the situation, just to gain some value with y'all, to be honest with you. To shorten this time with y'all being here so y'all can get back to y'all families. So looking at all the facts that were stated, the officer, there was no fear. This was just retaliation because she couldn't get me for nothing else. It's just simple as that. She's laughing, antagonizing. Really, if you ask me, just going outside of her way, if you ask me personally. I'm hoping y'all see it in the same light I was seeing it in. You've heard the statement from my children's mother. She was present. The children were present. None of them feel any harm. They wanted to go home with me. You heard that in the video. I think this was blown way out of proportion. If I was a threat, I had plenty of time to do it. If it was that big of a deal, besides taking a note of it, why wasn't I arrested and charged with it then? Bottom line. It shouldn't be something to be dragged out. If you want justice, do justice then. It's simple as that. I believe that's all I got for y'all. Thank y'all.
Colonel Bryson, do you have any?
No, Judge, I'll stand on my argument.
All right, then let me have one of you pass this out to the jury. All right, ladies and gentlemen, if you'll follow along with me. The defendant, Sheriff Mark Yvonne, is charged in the indictment with the crime of retaliation for past action. The defendant pleads not guilty to the indictment and to the offense contained therein. The evidence and arguments in this case have been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another, but should consider each one in the light of and in harmony with the others. The law presumes the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Dixon County, Tennessee, and that it was committed before the finding and returning of the presentment in this case. The burden is upon the state to prove by a preponderance of the evidence that this offense was committed in Dixon County, Tennessee. Proof by a preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dixon County, Tennessee, then you must return a verdict of not guilty. As heretofore stated in the indictment, the defendant is charged with the crime of retaliation for past action. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant threatened to harm the alleged victim by any unlawful act, and 2, that the alleged victim had been a law enforcement officer. 3, that the defendant did so in retaliation for anything the law enforcement officer did in an official capacity as a law enforcement officer, and 4, that the defendant acted either intentionally, knowingly, or recklessly. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. If you find the defendant guilty of retaliation for past action as charged in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall acquit the defendant of this offense. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. During your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. The verdict must represent the considered judgment of each juror. To return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. You can have no prejudice or sympathy or allow anything but the law and evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you will first select one of your members as foreman or forelady who will preside over your deliberations. When you have reached the verdict, you will return with it to this courtroom and your foreman or forelady will announce it. In reaching your verdict, you shall consider the offense charged in the indictment. If you unanimously find the defendant guilty of the offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense as to the defendant. On the other hand, if you find that the state has not proven beyond a reasonable doubt of the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. In that event, your foreperson will report that you found the defendant not guilty. If after your deliberations you find the defendant guilty, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. You may now retire for your deliberations. Ladies and gentlemen, I have prepared a verdict form that will help you in your decisions. It basically is just In the indictment for the charge of retaliation for past action, we, the jury, find the defendant, Sheriff Markey Vaughn, either not guilty or guilty, and then signed by the forelady. And let me sign that. Before we send you back, I need to select the alternate, and the person selected as the alternate will be excused from any further participation. You may leave, or you may wait around and see what your fellow jurors decide. So, let me get a paper clip. There you go. This will go in with all of the other exhibits when they go back.
Number 45, Bonnie Morgan.
Ms. Morgan, you are excused as the alternate. You can, as I say, you can leave or you can wait around. Do you have anything back in the jury room? All right, then if you'll just turn in your badge, and then you can either stick around and see what happens, or you can go about your business. All right, ladies and gentlemen, you now may retire to begin your deliberations, and the court will stand at recess pending the return of the honorable juries. I'm going to sit here and sign some documents, so I'm not getting up. All right. Everybody present, we're ready for the jury. I'm told the jury has reached a verdict, so we are ready for the jury to come in, so bring the jury in. We have everybody back. Let me get my court reporter in place, please. All right, ladies and gentlemen, I'm advised that you have reached a verdict. Is that correct? Would the foreman or the forelady please stand and let me ask this as to the charge in the indictment for the charge of retaliation for past action. How does the jury find the defendant, guilty or not guilty? All right. If this is the unanimous verdict of all of you, would you so signify by raising your hand? All right, let the record reflect that it's been a unanimous finding that the defendant is guilty of retaliation for past action. Ladies and gentlemen, thank you for your assistance in this regard. This was apparently my only trial that I'll have this term. October the 1st is a different judge, right? Judge Bateman, okay. You have a different judge who will be here for the October 1st date. So check that number. I'd like to be able to tell you that you don't have to serve again, but unfortunately we can't guarantee that just serving on one jury will exempt you. Once you're done with this term of court, you are exempt for 2 years, but you're still going to be on the hook, so to speak, until we finish with the term of court. All right, so ladies and gentlemen, you may leave if you'd like to exit through the doorway, and then the bailiffs will show you out. Let's have them exit through this way. And they'll show you how to exit the courthouse. If you'll turn your badge in to the bailiffs as well. Any items that you have in the jury room, please grab those. All right, the verdict was guilty, so we need to order a pre-sentence report. My suggestion is, General, that we set Mr. Vaughn's case on Monday, the 29th, for us to not only set the pre-sentence report or the sentencing hearing, but also to assign a trial date for his next case that is going to be tried. And I assume that would be one of the 3 cases he has remaining. Do you want to give that some thought, and we'll go from there? Mr. Vaughn, I want you to consider this at this point. As I explained to you, you elected to represent yourself in this case, and I think you've had kind of a taste on what that is like. In the next trial, I believe there's much more serious charges of aggravated kidnapping and aggravated assault and so forth, if I remember correctly. And I want you to consider between now and Monday whether or not you would want to have appointed counsel, actual counsel representing you, or whether you continue to represent yourself. If you continue to represent yourself, then I will not likely, unless there's some showing of a reason to appoint an advisory or elbow counsel for the remaining cases. So we will bring you back on Monday, and we'll set trial dates on those new cases and set a sentencing hearing. We stand adjourned until that time. So.
All rise.
These are all to be shredded.
Okay.
Sentencing hearing, yes, but if it's my copy, let me give you back your file. The ADA has not signed this. Is there any reason? I know they signed in a spot, but I still think they need to sign off on it. So.